Good afternoon here. We're going to start our formal portion of our board agenda. Before we get started, I would like to introduce you to Paula Farber, who is our new board counsel. If you have any questions or concerns about the board or the meeting, please contact her here at the division. All right, we're going to move on to item 1. Docket number 2024-037, cause number 132-44. In the matter of the request for agency action of Ventive USA, Inc. for an order pooling interests, including the compulsory pooling of certain non-consenting owners in the Knoll 13-10, 4-2-9-4-1, 1H well, identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Formation in sections 4 and 10, 4 south, 2 west, USM, Duchesne County, Utah. Mr. Mayo?
Ms. Garrison, Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, Ventive USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Gary White, Assistant Attorney General on behalf of the hearing examiner John Rogers.
John Rogers with the division.
Thank you. Mr. Mayo, back to you.
Thank you. It's been an unusual month due to the 24th holiday. So we had the hearing examiner hearing in these matters 2 weeks ago, and the orders have been finalized, is my understanding, according to the hearing examiner, and they should be set for him to present his recommendations here.
Thank you.
Thank you.
Mr. Rogers.
Okay, thank you. Good morning, Chairman Garrison and members of the board. My name is John Rogers, and I am Environmental Manager for the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. Mr. Gary White was my Attorney General, from the Attorney General's office was my counsel. This is a report of that hearing examiner proceedings. It was held on Wednesday, July 17, 2024 in this building. Chairman Garrison had read the request for agency action, so I won't proceed with that again if you're all right with that.
Yeah, that's
Okay,
fine.
great. As I said earlier, the proceeding was held as an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. No member of the public or other party was present at the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Ashley Ellison, Senior Land Negotiator, and Mr. Christopher Wall, Senior Reservoir Engineer, both from Ventive, and reviewed by me prior to the hearing. Mr. Mitch Mayo was also present at the hearing and acted as counsel for Ventive. Both of Ventive's witnesses were accepted by myself and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in this hearing. On July 10th, 2024, the division filed a response, a notice of non-opposition to the request for agency action, stating that in the division's opinion, Ventive had met its statutory regulatory requirements for compulsory pooling, and therefore the division does not oppose the petitioner's request for agency action. No other party filed a response or formally objected to Ventive's request for agency action, and no other party appeared or participated at the hearing. At the conclusion of the hearing, and based on evidence and testimony provided, the division expressed support for granting the request for agency action. A board order entered on February 23, 2018, cause number 139-150. The board established sections 4 and 9, Township 4 South, Range 2 West, Uinta Special Meridian as a drilling unit for the production of oil, gas, and associated hydrocarbons for the lower Green River Wasatch Formation. Ventive spud the subject well on September 19, 2018, and drilled it horizontally through the drilling unit and completed it as a producing well with its first production on January 22, 2019, with producing intervals in the Wasatch member of the subject formation. This was the first and only well drilled on this unit. As a consequence, allocation of production from the subject well is on a drilling unit basis at the date of first production. Because the subject well is the only well producing from the drilling unit and is payable on a 1280-acre conversion was not necessary from this order. It is not applicable in this drilling unit. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of Ventive. After reviewing the request for agency action, the sworn declarations, and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. Ventive has provided sufficient and adequate notice of opportunity to parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of these wells. I therefore recommend that 300% non-consent penalty be imposed as requested, and Ventive has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Ventive's counsel, Mr. Mitch Mayo, prepared the proposed finding of fact and conclusions of law and order granting its request for agency action. Both the division and I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. I will take any questions at this time if you have any.
Thank you. Division.
The division's in concurrence with Mr. Rogers' report, and I'd just like to express his thanks for how well he ran the hearings and the participation from Ventive and Mr. Mayor. And we know these hearings, these examiner hearings are provided in a more informal manner, but they do really allow us to, I guess, be able to ask questions that maybe we don't get to ask in the board of hearings, just because sometimes these issues that arise, the division aren't fully informed on what's going on, and so we get to get a little bit more background from the witnesses in those settings after we have the affidavits. But I just like to express our appreciation, and we're in concurrence with Mr. Rogers.
Thank you. Mr. Mayo.
Yeah, nothing to add to that except to echo what's been heard. I know this hearing examiner process has been it's been used in the past. This year it's been used much more consistently and regularly than usual, and it's been an adjustment period. But I have to agree, it gives a real opportunity for kind of informal discussion about issues surrounding the pooling, in addition to kind of the ministerial, checking of making sure that we did all the steps on this particular matter. But Mr. Rogers is for what it's worth, he's excellent at running those hearings. So the board should feel confident in delegating to him as a hearing examiner in the future if it needs to.
Thank you for the feedback. We appreciate it. Board, are there any questions?
Yes.
Mr. Church.
Mr. Rogers, what percentage of this well is being force pooled?
Well, I could dig it up here. I think it was
Just a matter of curiosity.
it was over 98%. Mitch, do you have that handy? Let me dig into here.
I have the number. You guys need it.
We've got Ventive witness Ash Ellison is on the line here. I've looked it up, but I think it's better if he answers, if that's all right. Should we have them sworn in? Does the board feel that necessary, or probably makes sense?
Just a matter of curiosity on my part.
Just curiosity.
This is another question for our AV people. We don't have the outside people on the screen. Oh, there we go. Thank you. It's magic.
Hello, everyone.
Ash, it sounds like just curiosity here. We'll swear you in if necessary, but can you answer the question?
Yeah, of course. The specific number is 0.34% is the interest that we are requesting to be compulsory pooled, force pooled.
Thank you very much.
Yes, sir.
Do we have any other questions? Are we ready to vote? Do I have a motion?
I'd like to make a motion to approve the request for agency action as requested.
And a second? I'll second. All those in favor, please say aye.
Aye.
Any opposed? Please note it was unanimous. And I believe we have the order here. All right. Thank you very much. I think the matter's concluded. We've got the order here.
Thank you. Appreciate
Thank
it.
you.
Thank you, everyone.
We're going to move on now to item number 2 on the docket. This is docket number 2024-038, cause number 132-45, in the matter of the request for agency action of Ventive USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Fitzgerald, Utah 9-35, 4-2-1-12-7H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Formation, comprised of sections 1 and 12, 4 South, 2 West, USM, Duchesne County. Mr. Mayo.
Yes, thank you, Madam Chair. Mitch Mayo again with Lear & Lear PLC on behalf of the petitioner, Ventive USA, Inc. I just wanted to confirm, it looks like I can see David Dale's on the camera here. Mr. Wall, I believe, is on as well, but just to confirm that we're ready to go. Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
And John Rogers, Environmental Manager at the division.
Mr. Mayo, do you have any opening comments?
No, none other than to say the hearing examiner process went smoothly, and Mr. Rogers, I believe, is ready with a prepared recommended order for the board.
Thank you. Mr. Rogers.
Okay, thank you. Good morning, Chairman Garrison and members of the board. My name is John Rogers, and I'm Environmental Manager with the Division of Oil, Gas, and Mining. I acted as a hearing examiner in this proceeding as directed by this board. Mr. Gary White from the Attorney General Office was my counsel. This is a report regarding that hearing examiner proceeding, and it was a hearing examiner proceeding was conducted on Wednesday, July 17th, 2024. And just like in the last matter, we had read the request for agency action before, so I'll forgo restating that.
Thank you.
The proceeding was held in this building in Salt Lake City, Utah, and no member of the public or any other party were present at the hearing. During the proceedings, 2 declarations and exhibits were admitted into evidence from Mr. David Dale, Manager of Rockies Land for Ventive, LLC, and Mr. Christopher Wall, Senior Reservoir Engineer, both from Ventive, and reviewed by me prior to the hearing. Mr. Mitch Mail was present at the hearing and acted as counsel for Ventive. Both were accepted by myself and the division as expert witnesses in their field of work in this matter. They also presented live testimony electronically at the hearing. On July 10th, 2024, the division filed a response, a notice of non-opposition to the request for agency action, stating that in the division's opinion, Ventive had met the statutory and regulatory requirements for compulsory pooling, and therefore the division does not oppose the petitioner's request for agency action. No other party filed a response or formally objected to Ventive's request for agency action, and no other party appeared or participated at the hearing. At the conclusion of the hearing, and based on the evidence and testimony provided, the division expressed support for granting the request for agency action. A board order was entered on February 23, 2018, in cause number 139-150. The board established Section 4 and 9, Township 4 South, Range 2 West, Uinta Special Meridian, as a drilling unit for the production of oil, gas, and associated hydrocarbons for the lower Green River Wasatch formations. Ventive spud the subject well on September 19, 2018, and drilled it horizontally through the drilling unit and completed it as a producing well with a first date of production of January 22, 2019, with producing intervals in the Wasatch member of the subject formation. This was the first and only well drilled on the unit. As a consequence, allocation of production of the subject well is on a drilling unit basis and will not need to be converted as stated in the 139-150 order.
Madam Chair, can I interrupt? I apologize. Can we have a quick 2-minute recess just so I can confer with counsel and make sure we're on the same page on something?
Sure.
I apologize for this.
No problem.
Thank you.
Did I?
See, he said 4 and 9, but it's here it's 1 and 12. So,
Yeah, it's 1 and 12 on there.
but he just, John just said he's referring to a drilling unit in sections 4 and 9. So that's the confusion I have.
Yeah.
That's the one before, but he just now said
Yeah.
4-9 this time.
Thank you, Madam Chair. I apologize. You know, with all the matters going on back and forth, there can get some confusion sometimes, and I think there may have been some kind of copy and paste mistakes when we were doing all this. I think the correction on the record: this unit is sections 1 and 12, not sections 4 and 9. Sections 4 and 9 was in the prior matter.
Right.
In addition, the date of first production of this well was actually July 19th, 2021. So I just want to clarify those couple of things for the record. If there's any confusion, it's in the kind of preparation of the report for the hearing, not in the matter as it goes forward. But we can clarify anything necessary as we go forward.
Okay.
John, Gary, is that sufficient?
Yeah, that
Thank-
work. I just,
Thank you for the corrections.
yeah, the order that was, the previous order, where it was mixed up, it was,
And I think in this proposed order, we have the correct
It is
sections
correct.
for this matter.
I apologize for that, but these were such similar matters, and the date of the orders were similar.
We'll try our hardest to keep it accurate.
Lots
here,
of numbers.
but the order has been vetted by Division Counsel, Board, or Hearing Examiner Counsel, and myself, so
Okay.
it should be accurate.
Thank you.
Okay. Thank you, Mr. Mayo, for correcting us on that. Okay, if that's straightened out. Well, let's see where we were.
One other, while Mr. Rogers is finding his spot, one other correction slash affirmation from what he said. There were no existing wells in this unit either, so conversion is not necessary or applicable to this order either, just to clarify.
So they
Thank you.
both were similar. They had the first wells on each unit with no conversion.
That's exactly
Okay.
right. Yep.
It's just simply the wrong section, so I apologize for that. Okay, so after that, the division, after reviewing the request for agency action and sworn declarations, admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommended the following. Ventive has provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable and should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that 300% non-consent penalty be imposed as requested. Ventive has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Ventive's counsel, Mr. Mitch Mayo, prepared the proposed finding of fact, conclusions of law, and order granting its request for agency action. Both the division and I reviewed and approved the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for the board's review and execution. I will take any questions that you may have at this time.
Board, do you have questions?
And Mr. Church, you asked about the last one. We're prepared on this one. The compulsory pulled amount was 0.21%.
Mr. Moon first.
Yeah, I was just thinking maybe my question should come a little later, but so there were two parties that elected to participate but did not sign JOAs. Have they subsequently signed JOAs, or is this order going to impose that JOA?
You're absolutely right. This order will not impose the JOA. Both parties during the pendency of this matter returned the signed JOAs, and Ventive obviously accepted those.
Okay.
And just to clarify, again, I think there might have been a misunderstanding. There was one party that was removed, so that percent just noted has changed. The percent pooled by this is really 0.036. So about 99.9% is voluntarily committed. I also, one other thing I'd like to just note for the board, you see probably a new face on the screen. David Dale is the manager for Rocky's Land for Ventive, but this was his first board hearing. He was qualified as an expert by the hearing examiner, and the division had a chance to talk with him. and ask him questions, but I'd like to obviously invite the board to do the same if they have any questions for Mr. Dale or about this matter in particular.
Thank you. Seeing no questions, let's proceed. Division, do you have any comments?
The division's in concurrence with Mr. Rogers' report, and we
Thank
have no
you.
other comments.
Thank you. Mr. Mayo, any closing comments?
No, I appreciate the board's understanding. There are times where there's just too many matters going and things get confused. I want to assure the board, though, that counsel for the division, counsel for the hearing examiner, and myself take our duty to make sure the facts are clearly stated in the pleadings and in the final orders very seriously. So I'd just like to note that, despite any confusions that we may kick in here and there, the board can have ultimate confidence that the order has been vetted. So thank you for that.
Thanks. Board, do we need to have a motion to accept?
I move that we approve this request for agency action as it pertains to sections 1 and 12 of Township 4 South, Range 2 West.
I second.
Thank you. All in favor?
Aye.
Any opposed? Please note it passes unanimously. Thank you, Mr. Mayo. Appreciate it. And we've got the order here,
Thank you.
which she has reviewed and said is all correct. So we're
Perfect. If
We're
there are
good.
any confusions or questions after the fact, obviously you know how to get a hold of me. Am I allowed to be dismissed for the day, Ms. Garrison?
if you're not on the next three issues, you may be excused.
If I go fast enough, I won't be. Thank you much.
Thank you. Thank you. I think we're ready to proceed with item number 3 on the docket. This is docket number 2024-036, cause number 132-43. In the matter of the request for agency action of Ventive USA, Inc. for an order pooling interests, including the compulsory pooling of certain interests of certain non-consenting owners in the Virginia 14-12, 3-2-12-1-5H, and the 14-12, 3-2-12-1-7H wells in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 1 and 12, 3 South, 2 West, USM, Duchesne County, Utah. Mr. McDonald.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Ventive USA, Inc.
Thank you. Division.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining. And at the table with me are division experts Peter Pankey and Colton Goodrich.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today, appearing virtually pursuant to the board's July 15th order, are Mr. Peter Burns, Land Advisor, and Mr. Christopher Wall, the Reservoir Engineering Advisor. I'd ask that they both be sworn in at this time.
We don't have them on the monitors.
They should be on now.
Thank you.
Yep.
Please
raise your right hands. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes.
The resumes of both witnesses were collectively submitted as Exhibit 1. If separately asked, each would verify the contents of their resumes are true and correct. Both Mr. Burns and Mr. Wall have previously been recognized by the board on several occasions as experts in petroleum land management and petroleum engineering, respectively. Presuming the division has no objections, I ask that the board again recognize them as experts in those disciplines for purposes of this cause.
So recognized.
No objection?
No objection.
All right, thank you.
Sorry, I jumped the gun there.
No worries, thank you.
Also,
Please.
I will be moving forward mission of our exhibits at the as a whole at the end of our presentation in chief.
Thank you.
Madam Chair and members of the board, this cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 1 and 12 of Township 3 South, Range 2 West in Duchesne County. This drilling unit was established by the board's order in cause number 139-134. A true and correct copy of the 139-134 order was submitted as Exhibit 2. The 139-134 order modified previous board orders entered in cause numbers 131-51 and 139-90, which established sections 1 and 12 respectively as sectional drilling units for Lower Green River Wasatch production. Harvest U.S. Holdings, Inc. and Newfield Production Company, Ventive's predecessors by assignment, merger, and name change, had previously drilled 2 wells, one in Section 1 and the other in Section 12. Pursuant to the 139-90 order, production from these wells was allocated on the sectional drilling unit basis. No compulsory pooling order for those wells was required because Newfield was the only working interest owner. Pursuant to the board's order entered in cause number 139-120, a special pilot drilling unit was created for the Bar F interval, being portions of the Lower Green River Wasatch, comprised of sections 12 and 13 of the captioned township. Newfield drilled the Povich long lateral horizontal well in accordance with that order. The board then entered the 139-134 order, which expressly provides, sorry, is this mic working okay? Okay, all right. The 139-134 order expressly provides that production allocation from the 2 existing wells converted to the Section 1 and 12 drilling unit basis as of the first of the month following the date of first production of the first long lateral horizontal well drilled upon the Sections 1 and 12 drilling unit. The 139-134 order also provides that upon the first of the month following the date of first production of the first long lateral horizontal well drilled upon the Sections 1 and 12 drilling unit, or the concurrently established adjacent Section 13 and 24 drilling unit, allocation from the Povich well would be allocated 50% to the Section 1 and 12 drilling unit. In accordance with the 139-134 order, Ventive drilled the 2 Virginia wells at issue, both with a date of first production on July 14th, 2022. As a consequence, conversion with respect to the 2 existing wells occurred on, and production from the Provich well was allocated 50% to the Section 1 and 12 drilling unit as of August 1st, 2022. As alleged in the request for agency action, and as will be established by Mr. Burns' testimony, some of the fee leases were granted by parties claiming buy-through under the estates of certain deceased parties identified in the request, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete with respect to proper distribution to the heirs or devisees. As such, there is the possibility that some unknown party claiming buy-through or under these estates is unleased and therefore not pooled. Consequently, as to those unknown heirs or successors, pursuant to the board's order entered on June 12, 2024, the requisite notices of opportunity to lease or participate pertaining to the Virginia wells were published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to those notices or otherwise tendered his or her share of the cost for the Virginia wells. Ventive therefore seeks to have these parties compulsory pooled and also declared as non-consenting owners. The proof of publication to those unknown parties was submitted as Exhibit 8. As to the non-consenting parties, Ventive seeks imposition of a 300% risk compensation award in the terms of a joint operating agreement, which terms have been previously deemed just and reasonable by the board in many other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 15.659927% cost-free royalty, representing the average weighted fee royalty in the drilling unit, calculated as of the date of spud of each of the 2 Virginia wells. Royalties under Indian and state leases by statute is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R649-2-8A and R649-2-9A. A copy of the request was mailed via regular mail to all other production interest owners within the Section 1 and 12 drilling unit at their last addresses disclosed by the relevant realty records, and to the Ute Tribe, Ute Distribution Corporation, the Bureau of Indian Affairs, and the Bureau of Land Management, which is the technical advisor to the Bureau of Indian Affairs, due to the mineral ownership of the Indians, Sitla, and the Division of Forestry, Fire, and State Lands within the drilling unit. In addition to the published notice of opportunity to lease or participate in the Uinta Basin Standard previously mentioned, notice of the filing of the request and of this hearing was duly published in the Uinta Basin Standard on July 3rd, 2024, in the Deseret News on July 5th, 2024, and in the Salt Lake Tribune on July 7th, 2024. On July 9th, 2024, the division filed a response expressing no opposition to the request for agency action. No other objections or responses to the request were timely filed, and since none of the alleged non-consenting parties filed a timely response to the request, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, I move to enter an order of default against them.
No objection.
Thank you. With that, I'll commence my examination of Mr. Burns. If we could have Mr. Burns up on the screens, please.
Stand by.
There he is. Mr. Burns, please state your name and business address for the record.
Yes, Peter Burns, and Ventive's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
What's your current position with Ventive and its relation to this matter?
I am a land advisor within the Uinta team with responsibility over this DSU.
Please state the corporate and bonding status of Ventive for purposes of the record.
Sure. Ventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It's duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by assignment from Harvest U.S. Holdings, Inc. and name change to Newfield Production Company, and by merger of Ventive Production, Inc.
Mr. Burns, I'm now going to direct your attention what have been marked as Exhibits 3 through 7. They're shown on the PowerPoint, which I'm assuming you can see. Do you recognize these exhibits?
Yes.
Were they prepared by you or Ventive personnel with your review and input?
Yes.
Turning your attention to Exhibit 3, would you please explain what this shows?
Yes. Exhibit 3 is a regional locator plat with the DSU at issue highlighted in red. This is located 2 miles due north of the Mighton Town site and adjacent to Highway 40.
Now turning your attention to Exhibit 4, would you please explain what this shows?
Yes, Exhibit 4 is a snapshot of the BLM master title plat, reflecting the various lots in Section 1. And this results in a total DSU gross acreage of 1,282.12 acres.
Now turning your attention to Exhibit 5, would you please explain what this shows and its significance to today's hearing?
Yes, Exhibit 5 shows the general locations of the wells within the DSU and the general type of oil and gas ownership within. The Virginia 5H well traverses the east half, west half of the DSU, while the Virginia 7H well traverses the west half of the DSU. And as outlined in the RAA pursuant to the 139-134 order and APDs approved by the division, the 5H well was spud on April 8th, 2022, and completed as a producing oil well with productive intervals in the Uteland Butte member of the space formations. The date of first production was July 14th, 2022. The 7H well was spud on April 16th, 2022, and completed as a producing oil well with productive intervals in the Uteland Butte member of the space formations, and its date of first production was also July 14th, 2022. Also shown are the Tomlin and Dart wells, the existing directionally drilled and vertical wells within the DSU, now operated by Ventive. Pursuant to the 139-134 order, production allocation from these 2 wells converted to the DSU basis effective on August 1st, 2022. No compulsory pooling order relating to those wells was ever sought because Newfield was the only working interest owner. And not shown here on the plat is the Povich well, which was drilled pursuant to the 139-120 order as outlined in the RAA and by Mr. McDonald previously. It extends into the west half, east half of Section 12 and produces from the bar F interval of the space formations. Pursuant to the 139-134 order, production allocation from this well converted 50% to Sections 1 and 12, also on August 1st, 2022, which was the date of conversion.
Now turning your attention to Exhibit 6, this is a 3-page exhibit. Would you please explain to the board what this exhibit shows?
Yes, Exhibit 6 is a plat and with descriptions of the oil and gas ownership tracts in Sections 1 and 12. This particular slide here is very colorful, describes all of the different tracts, and in total there are 25 different tracts within this DSU. Tracks 1 and 8 and 14 are SITLA tracts. Track 2 is a tribal tract, and tracks 4 and 23 are UDOT, Division of Forestry, Fire, and State Land tracts.
And just as a reminder to the board, again, the Indian and state leases royalties are not utilized by pursuant to statute in the average weighted fee calculation. Okay, now finally turning your attention to Exhibit 7, would you please explain to the board what this shows?
Yes, Exhibit 7 is a DSU working interest ownership summary slide. As you can see, Ventive is the majority lessee working interest owner in the DSU and is the operator of all the wells located thereon. Other than the parties sought to be compulsory pooled here, which are estates only, Ventive is the only working interest owner. We have recorded a pooling declaration pooling the fee leases in the DSU. We've also submitted both ratifications to SITLA and the Division of Forestry, Fire, State Lands relating to the state leases. We've also submitted a communitization agreement to effectively pool the tribal lease with the fee leases, and that communitization agreement is pending BIA approval.
Okay, just for clarification again, then, Ventive, based on its research, believes it has all of these successors of these estates under lease, but is doing this as a protective measure in case there's somebody else out there that your research hasn't shown. Is that correct?
Yes, that's correct.
Okay, now turning your attention to those parties, can you please address the notice of opportunity to participate and what that involves? Who are these parties and what have you done about it?
Yes, so as Mr. McDonald mentioned, there are several lessors that claim title in these lands through one or more of the estates.
Let me just ask the board, if you want, he can list all these parties off, or if you want him to just refer to the request, the parties are listed there. That would be fine, referring to the request. Okay, we'll do that. So, Mr. Burns, you don't have to read off all those names.
Okay. Yeah, so there are, over 24 names here claiming by, through, and under these estates, all listed within the RAA. But for each of these, either no Utah probate of the estates has been initiated, or if it's been filed, they're incomplete and that there's been no proper distribution made to the heirs or devisees. And although based on affidavits of heirship and other inquiries and research done by our lease broker, and except for the specific parties previously identified, we believe we have leased all of their successors, but without an order from the Utah court confirming their succession, the possibility exists that unknown successors may establish succession. Such owners would be unleased, and therefore we seek to compulsory pool their interests.
All right, referring to Exhibit 8, which there's no PowerPoint for, but you have in front of you, that's the public proof of publication provided by the Uinta Basin Standard. That's an official business record of Ventive, is that correct?
Yes, it is.
Did you receive any responses to that published notice?
No, we did not.
Okay, now turning your attention to Exhibit 9. This is a 4-page exhibit. I'm just going to show the last page there. Was that prepared by you or a Ventive personnel with your review and input?
Yes.
Okay, please explain what this shows.
So Exhibit 9 is the last slide within the average weighted royalty calculation. This reflects the calculation of the average weighted fee landowner's royalty for the drilling unit as of the date of spud of each of the 2 Virginia wells. And in this case, the calculation yields a total of 15.659927%. And again, this does not include any Indian or state royalty per statute.
Okay, now directing your attention to Exhibit 10, which was also Exhibit A to the request. Was that document prepared by you or Ventive personnel with your review and input?
Yes.
All right, please explain what that document is and the significant portions relevant to compulsory pooling.
Sure. Exhibit 10 is the proposed JOA for this pooling order. This form utilizes the standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. The terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units. Ventive has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators. So the key components here within the JOA are page 7. This addresses the non-consent penalty, and in this case, a 100%, 300% non-consent penalty is shown. And then also on Exhibit C of the JOA, this is the COPUS accounting procedure form. Again, this is a standard industry form, almost universally utilized, similar to other JOAs in the Uinta Basin. The key points here are found on page C3. Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%. which has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses. And lastly, on page C9, it outlines the overhead charges. And in this case, this is at $11,403.62 for the drilling rate and $1,140.35 for the producing rate. And the Exhibit A to the JOA will be amended if and any of the unknowns are ultimately identified and their DSU gross working interests are determined.
Is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by other working interest owners, commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right, would you confirm for the record all other of the land allegations of the request?
Yes.
All right, turning the attention to the certificate of service and the supplemental certificates of service that are pleadings prepared by my office and on file in this cause. Do you have those in front of you?
Yes.
All right, could you please identify who those parties are and how they were determined?
Sure. The people shown are all the production interest owners within this DSU. The addresses are derived from a title opinion effective as of February 28th, 2022, as updated by a search of the county records by Lone Wolf, our lease broker, and Ventive Zone internal records. Also the tribe, UDC, SITLA, UDOT, and Division of Forestry, Fire, State Lands, and all governing federal agencies are also included.
Madam Chair, with that, that concludes my examination of Mr. Burns.
Thank you. Division.
The division has no questions for this witness. Thank you.
Board. Mr. Moon.
Yeah, what's the status of payout on these two wells?
I do not have that information in front of me, but I believe they are close to have paid out, if not already.
Thank you.
Board, any other questions? Mr. Church.
Yes, Mr. Burns, would you review with me the status of the Povich well and again how that relates? It was a unit for 12 and 13, and now it goes into this drilling unit of 1 and 12, and you say it's converted. How does that relate to its production for the what may be coming out of Section 13 production in that well?
Yeah, so I guess we would call like most of Ventive's drilling and Newfield's drilling prior to that was on pattern, so to speak. So sections 1 and 12 were drilled as a 1280 together. But the Povich well was drilled sort of off pattern, if that makes sense. It was drilled in sections 12 and 13. And so I believe it's under the 139-120 spacing order, which allowed that. And I believe it was sort of a pilot spacing order test to drill that well off pattern. And so under the 139-134 order, that specifically addressed the Povich well and said that whenever we drilled the 1 and 12 DSU or the 13 and 24 DSU, whichever was first, that Povich well would then be reallocated and converted to 50% into each of those 1280s, if that makes sense. So on the same day the Tomlin and Dart wells converted to 1280, the Povich well did the same.
So half of the production from the Povich well is allocated to the DSU 1 and 12, and then half
Yes.
of the production is to the southern DSU.
Yes.
Okay, thank you.
Just a quick.
Mr. Moon.
But the southern section 13, there's not a 1280 in 13 and 24. Is there? So is it still just on a 640 basis, or is it it is full?
Yes, I believe that's our Fawcett DSU. So there are 1280 wells within there as well.
Okay. Okay.
Board, any other questions? Mr. McDonald?
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, Christopher Wall. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
All right, and what is your current position with Ventive?
I'm a reservoir engineering advisor for Ventive with jurisdiction over this DSU as well as others in the Uinta Basin.
All right, now referring your attention to Exhibit 11, this is a 2-page exhibit. Was this prepared by you or Ventive personnel with your review and input?
Yes.
Would you please explain what it shows, starting with the first page, 11A?
Sure. Exhibit 11 is summary of the actual costs invoiced to Ventive and incurred in drilling and completing operating costs for each of the Virginia wells through April 30th, 2024.
Okay, so the A was for the 5H well and B is for the 7H well. Is that correct?
That's correct.
Okay. Is it your expert opinion that these costs were fair, reasonably, and necessary?
Yes.
And that the wells were deemed economically feasible, as that term is used in the 139-134 order to drill?
Yes.
Okay. Would you please, for the record, what is your opinion on the plugging and abandonment cost for each of these wells?
Yes. P&A cost estimate is $75,000 per well, which is consistent with Uinta Basin P&A costs charged to and by Ventive, and that's based on 100% working interest.
Okay, now turning your attention to what have been marked as Exhibits 12 and 13. Do you recognize these exhibits?
Yes.
Were they prepared by you or Ventive personnel with your review and input?
Yes.
Okay, starting with Exhibit 12, would you please explain what this shows and its significance to today's hearing?
Yes, Exhibit 12 is a plot of nearby existing horizontal development at the time the Virginia wells were spud.
And the Virginia wells are Uteland Butte wells, is that correct?
That is correct, yes.
So the relevant ones for the success of the Uteland Butte are shown in green on this exhibit?
That's correct, yes.
Okay, now turning your attention to Exhibit 13, would you please explain what this shows and go through the points?
Sure. So Exhibit 13 is a summary of the risks that are involved in oil and gas development in the Uinta Basin. First is the geologic risk. There's variable stratigraphy, particularly the presence of high clay intervals and other structurally weak zones leading to possible hole stability issues. On the operation side, in drilling, shallow hazards with artisanal water flows are occasionally encountered. The Uteland Butte interval has high clay with potential to collapse and stick drill pipe and casing. And some recent examples of that is the collapsed casing during a completions activity of the Black Hare 7H and the Bruce 42H in this year. Cementing challenges resulting in a loss of lateral footage in the Tomlin 46H. We've also sheared a BHA while attempting to steer in lateral, resulting in short laterals, the Abbott 46H in 2022. On the commercial side, there's future oil price and gas uncertainty, as well as future refinery and rail car availability to ship the product. The actual occurrences on these particular two wells, the Virginia 5H had really high mud costs due to hole conditioning and losses. And then the Virginia 7H encountered a high shale content, causing the drilling assembly to get stuck and the lateral was sidetracked. We lost 3,800 feet of drill pipe and other tools in the lateral and spent 11 additional days drilling.
Is it your expert opinion then that for these reasons a 300% risk assessment award is justified?
Yes.
All right. Would you confirm for the record all the other engineering related allegations of the request?
Yes.
All right, Madam Chair, that concludes my examination, Mr. Wall.
Thank you. Division.
No questions, thank you.
Board, do you have questions? Seeing none, please proceed.
Thank you, Madam Chair. With that, I'll move for admission of Exhibits 1 through 13 inclusive.
No objection.
Thank you. Thank you. So admitted.
All right, thank you. With that, just to let the board know, the reason we didn't do this one in front of a hearing examiner was because both myself and Mr. Burns were unavailable on the hearing examiner date. Normally we would do that, so that's why we're before you here today. Other than that, again, this is more a protection compulsory pooling here. If one of these parties comes out of the woodwork from one of these estates, then we want to make sure that they're compulsory pooled, so that's why we're before you. Ventive has met all the statutory and regulatory requirements, and we would ask that you approve the request as submitted.
Okay. Board, do we have any questions? Mr. Moon?
So I'll make the motion. Just an observation. So that cost, the two wells were about $2.5 million difference. So that extra 8 or 10 days for the stuck drill pipe, it's pretty costly per day. Just thought that was interesting. About $2.5 million more for the one well versus the other. So I'll move that we approve this request.
Madam Chair, do you want
action.
to? Madam Chair, if I can interrupt and ask the division if they have any thing they'd like to add.
Oh, okay. Division, please.
I don't have anything to add. We've reviewed the materials and the exhibits as well as the, based on the testimony today, the division has no objection to granting this request.
Thank you. Mr. Moon,
Move we accept this request for agency action.
do we have a second? Second. All in favor?
Aye.
Any opposed? Please show it was unanimous. Thank you, Mr. McDonald. Will you prepare the order?
I will, and thank you again, board, for allowing the witness to appear virtually, and to the IT people for making it go smoothly.
Thank you. Are you presenting item number 4 also?
Yes, ma'am.
Okay. Are you ready to begin?
Give me 1
I'll
second.
give you a minute.
Okay, we're ready now.
Thank you. We're moving on to docket item number 4. This is docket number 2024-039, cause number 132-46. In the matter of the request for agency action of Ventive USA, Inc. for an order pooling interests, including the compulsory pooling of certain interest of certain non-consenting owners in the Bar F Utah 16-20, 3-2-29-32-1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 29 and 32, 3 south, 2 west, USM, Duchesne County, Utah. Mr. McDonald.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner Ventive USA, Inc.
Division.
Assistant Attorney General Gary White, on behalf of the Division of Oil, Gas, and Mining, and I'm here with division experts Peter Pankey and Colton Goodrich.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me again today, appearing virtually pursuant to the board's July 15th authorization, are Mr. Peter Burns, Land Advisor, and Mr. Christopher Wall, Reservoir Engineering Advisor. If we could have them appear on the screen, please. Thank you. I would ask that these witnesses be sworn in at this time.
Please raise your right hands. Do you solemnly swear that the testimony you shall give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes.
Thank you. The resumes of both witnesses was collectively submitted as Exhibit 1 in this matter. If separately asked, each would confirm the truth and veracity of their resumes. As you know, Mr. Burns and Mr. Wall have been recognized as experts in the fields of petroleum land management and petroleum engineering, respectively, on several matters. Again, presuming the division has no objection, I would ask that they be recognized as experts in those disciplines for purposes of this cause.
Division.
No objection. Thank you.
Board. So accepted.
Thank you. I also want to confirm that the board received the supplement to Exhibit 17, which is just the update of the confirmed receipt by one of the parties that's to be compulsory pooled on Monday.
Yes, we've accepted.
Thank you. And also, again, I will be moving for admission of our exhibits in whole at the end of the presentation in chief. Madam Chair and members of the board, this cause involves the compulsory pooling of the drilling unit established for the lower Green River Wasatch production comprised of the entirety of sections 29 and 32 of Township 4 South, Range 2 West in Duchesne County. This drilling unit was established by the board's order entered in cause number 139-134. Again, a true and correct copy of the 139-134 order was submitted as Exhibit 2 in this matter. The 139-134 order modified the board's order entered in cause number 139-90, which established sections 29 and 32 respectively as sectional drilling units for the Lower Green River Wasatch production. Newfield Production Company, Ovino's predecessor by name change and merger, had previously drilled 2 wells within section 29. Pursuant to the 139-90 order, production from those 2 wells was allocated on the sectional drilling unit basis. No compulsory pooling order was required because the only non-consenting owner had signed a joint operating agreement voluntarily pooling its interest and which controlled the consequences of its participation election. Ventive has since acquired that party's interest. The board then entered the 139-134 order, which expressly provides that production from those existing wells converted to the section 29 and 32 drilling unit basis as of the first of the month following the date of first production of the first long lateral horizontal well drilled on the drilling unit as established thereunder. In accordance with the 139-134 order, Newfield drilled the subject Bar F well with a date of first production on December 29, 2017. As a consequence, conversion with respect to the 2 existing wells occurred on January 1, 2018. As alleged in the request and as will be established by Mr. Burns' testimony today, Richard D. Roundy was provided, both by mail and publication, the requisite notice of opportunity to participate in the Bar F well, but the mailing was unclaimed and he otherwise failed to properly respond within the 30-day time period set by regulation. As such, Ventive seeks to compulsory pool him in this drilling unit and to declare him as a non-consenting owner in the Bar F well. Furthermore, some of the fee leases were granted by parties claiming by-through or under estates of certain deceased parties as identified in the request, and for whom no confirmatory Utah probate proceedings either have been initiated or, if initiated, have not been properly completed to allow distribution to the heirs or devisees. As such, there's the possibility that some unknown party claiming by-through or under these estates is unleased and therefore not pooled. Consequently, as to both Mr. Roundy and these potential unknown heirs or successors, pursuant to the board's order entered on June 12, 2024, the requisite notice of opportunity to participate was published in the Uinta Basin Standard for 2 consecutive weeks. No party has responded to the notice or otherwise tendered his or her share of the cost for the well. Ventive therefore seeks to have these parties to be compulsory pooled and also declared as non-consenting owners. The proof of publication of Mr. Roundy and these unlocatable or unknown parties was submitted as Exhibit 12. As to the non-consenting parties, Ventive seeks imposition of a 300% risk compensation award and the terms of a joint operating agreement, which terms have been previously deemed just and reasonable by the board and many other compulsory pooling hearings. During the recoupment period, Mr. Roundy and the unleased non-consenting owners will be entitled to a 17.423578% cost fee royalty, representing the average weighted fee royalty in the drilling unit, calculated as of the date of spud of the Bar F well. Again, royalty under Indian leases by statute is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations at R 649-2-8A and R 649-2-9A. A copy of the request was mailed certified mail to Mr. Roundy and mailed regular mail to all other production interest owners within the drilling unit at their last known addresses disclosed by the relevant realty records, and to the Ute Tribe, Ute Distribution Corporation, the Bureau of Indian Affairs, and the BLM as the technical advisor to the Bureau of Indian Affairs, because of the mineral ownership of the Indians within the drilling unit. In addition to the notice of opportunity to participate in the previous that was published in the Uinta Basin Standard previously mentioned, notice of the filing of the request and the hearing thereon was also duly published in the Uinta Basin Standard on July 3rd, 2024, in the Deseret News on July 5th, 2024, and in the Salt Lake Tribune on July 7th, 2024. On July 9th, 2024, the division filed a response expressing no opposition to the granting of the request for agency action. No other objections or responses to the request were timely filed, And as such, we request that the parties pursuant to Utah Administrative Code R641-104-150 and R641-108-400 have an order of default against them.
Division?
I doubt we'll object, but I would like to hear from the witness before we respond about how it was that they determined where Mr. Roundy lives.
Okay.
Fair enough. Okay, so we'll reserve, and I'll ask for that motion again after that testimony.
Thank you.
Okay.
All right.
Board? Accepted. Let's go.
Thank you, Madam Chair. With that, I'll commence my examination. Mr. Burns, please state your name and business address for the record.
Yes. Peter Burns, and Oventive's address is 4 Waterway Square Place, Suite 100, in the Woodlands, Texas, 77380.
And what's your current position with Oventive?
I'm a land advisor within the Uinta team here with responsibility over this drilling unit, among others.
Would you please state the corporate and bonding status of Oventive for purposes of this cause?
Yes. Ventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of Ventive Production, Inc.
Turning your attention to what have been marked as Exhibits 3 through 7, which are shown on the PowerPoint here. Do you recognize these exhibits?
Yes.
Were they prepared by you or Oventive personnel with your review and input?
Yes.
Starting with Exhibit 3, would you please explain what this shows?
Yes. Exhibit 3 is a regional locator map showing the subject sections 29 and 32 of Township 3 South, Range 2 West, highlighted in red. This DSU is traversed by Highway US 40 and is between the Bridgeland community and the Mighton town site.
Now turning your attention to Exhibit 4, would you please explain what this shows?
Yes, Exhibit 4 is the snapshot of the BLM master title plat, reflecting the various lots in sections 29 and 32 due to the Duchesne River. Nevertheless, the DSU acreage is a normal 1,280 acres.
Now turning your attention to Exhibit 5, would you please explain what this shows and its significance to today's hearing?
Yes, Exhibit 5 shows the general locations of the wells within this DSU and the general type of oil and gas ownership therein. The Bar F well traverses the east half of the DSU. It was spud on October 12th, 2017, and completed as a producing oil well with productive intervals in the Uteland Butte member of the Space Formation. Its date of first production was December 29th, 2017. Also shown are the Abbott and Larson wells, the existing vertical and short lateral horizontal wells within this DSU, which are both operated by Ventive. Pursuant to the 139-134 order, production allocation from these two wells converted to the DSU basis effective January 1st, 2018. No compulsory pooling orders for these two wells were sought because New Fuel was the only working interest owner therein.
Now turning your attention to Exhibit 6, this is a 2-page exhibit. Would you please explain what this shows?
Yes, Exhibit 6 is a plat and descriptions of the oil and gas ownership tracts within sections 29 and 32. This DSU has 21 different mineral tracts, tracts 8, 10, 14, and 19, and 98.958333% of tract 9, along with 98.33% of tract 15 and 99.484127% of tract 20 are Indian allotted tracts. Tract 21 is tribal, and the remainder is fee ownership.
And again, just a reminder that the Indian royalty is not included in the average weighted fee royalty calculation. Turning your attention now to Exhibit 7, would you please explain to the board what this shows?
Yes, Exhibit 7 is a DSU working interest ownership summary slide. As you can see, Ventive is the majority lessee working interest owner in this DSU and is the operator of the Bar F well. We have recorded a pooling declaration, pooling the fee leases in this DSU, and we've secured approval of a communitization agreement, effectively pooling the tribal and allotted leases with the fee leases.
All right, and we will address the figures shown for the compulsory pooled interest shortly. Now, Mr. Burns, I'm going to direct your attention to Exhibits 8 through 12. We do not have a PowerPoint on those. Are those official business records of Ventive?
Yes.
All right, starting with Exhibit 8, would you please please explain what that shows?
Yes, Exhibit 8 is the notice of opportunity to participate sent to Richard D. Roundy, the owner of an unleased undivided oil and gas interest, which equates to a 0.048971% gross working interest in the DSU as reflected on Exhibit 7. However, it was returned as unclaimed. With the board's authorization, the notice of opportunity to participate was then additionally provided by publication.
Following up Mr. White's request, could you explain what all did Ventive do to try and locate Mr. Roundy?
I mean, a search of the realty records to try to locate a better address. We subscribe to a number of different sites, or Lone Wolf Energy does, to try to find these better addresses, and they have people that their sole job is to search for better addresses when we get these items back as unclaimed or undeliverable. Just numerous website searches and speaking with family members if there are any available. But in this case, we were not able to find a better address.
And again, that's why you directed or asked the board for permission to provide the notice through publication to him. And just as a reminder too, with the board's authorization for that publication, Ventive submitted an affidavit of good faith efforts to locate him, which the board accepted by allowing the notice of publication.
Yes.
Mr. Burns, now turning your attention to Exhibit 9, would you please explain what that shows?
Sure. Exhibit 9 is the survey plat for the Bar F well that was sent with the notice of opportunity to participate.
All right, and turning to Exhibit 10, please explain what that is.
Yes, Exhibit 10 is the AFE that was sent with the notice, and Mr. Wall will testify as to the actual costs invoiced and incurred.
Mr. McDonald?
Yes.
We're behind on the exhibits on the monitors.
Those weren't provided on the PowerPoint.
Thank you.
All right. Exhibits 8 through 10 were comply with the regulatory requirements of R649-1-1 and R649-2A as part of the notice of opportunity to participate. All right, Mr. Burns, addressing the unknown parties, would you please explain who they are? Again, with the board, if the board would prefer, we'll just refer to those estates as set forth in the request rather than having them read out.
Thank you. That's fine.
All right, Mr. Burns, again, please address those unknown parties and what you've done with respect to them.
Sure. So as Mr. McDonald mentioned, there are several lessors claim title in these lands through one or more of the estates that were all listed within the request for agency action. And for each of these owners or estates, either no Utah probate of the estates has been initiated, or if it's been filed, they're incomplete in that there has been no proper distribution made to the heirs or devisees. Although based on affidavits of heirship and other inquiries and research done by Ventive's lease broker, and except for the specific parties previously identified to be compulsory pooled and declared as non-consenting owners, Ventive believes it or the other voluntarily pooled working interest owners have leased all of their successors, but without an order from a Utah court confirming their succession, possibility exists that unknown successors may establish succession. Such owners would be unleased, and therefore Ventive seeks to compulsory pool their interests.
All right, I'm going to refer you to Exhibit 12. That's the proof of publication to Mr. Roundy and those unknown heirs or devisees supplied by the Uinta Basin Standard. That's an official business record of Ventive, is that correct?
Yes.
And did you receive any responses to that published notice?
No, we did not.
All right, turning your attention now to Exhibit 11, which was also Exhibit A to the request. Please explain what that document is and its relevant provisions to the compulsory pooling action.
Sure. Exhibit 11 is the proposed JOA for this pooling order. This is a form utilized as a standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version with modifications to address horizontal wells. Exhibit 11 is materially the same form JOA sent with the mailed notice of opportunity to participate to Mr. Roundy. The terms and conditions contained therein, including the modifications made, are consistent with and commonly found in horizontal well drilling units. Ventive has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which we are a non-operator, including those operated by Uinta Wax, Javelin, and other major Uinta Basin operators. So specifically for the JOA, the key points are found on page 7 of the JOA, which addresses the non-consent penalty. In this case, a 100%, 300% non-consent penalty is provided. And then moving to Exhibit C of the JOA, which is the COPUS accounting procedure exhibit. Again, this is a standard industry form, almost universally utilized, similar to other JOAs within the Uinta Basin. The key points within this exhibit are found on page C3. Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%. And this has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses. And lastly, on page C9, this outlines the overhead charges. And in this case, $10,090 and $1,090 are stated for the drilling and producing rates. And the Exhibit A to the JOA will be amended if and once Mr. Roundy or any of the estates are ultimately identified and their DSU gross working interests are determined.
All right, just to clarify, we know what Mr. Roundy's interest is. It'd be the unknown parties. That's what you mean to amend?
Yes, sorry, my mistake there. Yes, it would just be any of the estates.
All right. Is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those commonly accepted by industry, and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
All right, now turning your attention to Exhibit 13. This is a 5-page exhibit. I'm just going to show you the last page. Was this prepared by you or Ventive personnel with your review and input?
Yes.
Okay, would you please explain what this shows?
Yes, so Exhibit 13 is the average weighted royalty calculation, and this calculation for the drilling unit as of the date of the Bar F well comes to 17.423578%. And again, this does not include any Indian royalty per statute.
All right, would you confirm for the record all the other land allegations of the request?
Yes.
All right, now turning your attention to the certificate of service, which is a pleading that was prepared by my office and on file in this cause. Do you have a copy of that in front of you?
Yes.
Would you please explain who those people are and how they were identified?
Yes, the people shown are all of the production interest owners within the DSU. The addresses were derived from title opinions effective as of April 29th, 2007 and June 8th, 2017, as updated by a search of the BIA, BLM, and county records by Lone Wolf and Ventive's internal records. This certificate of service was also sent to the tribe, UDC, the Vernal Field Office of the BLM, and the USO of the BLM and BIA.
All right, and Exhibit 17 is supplemented is the status of the certified mailing to the request to Mr. Roundy, and that's on file with the board. With that, Madam Chair, that concludes my examination of Mr. Burns.
Division.
Thank you, Mr. Burns. Just a few follow-up questions. If we could go back to Exhibit 8.
I'm sorry?
Exhibit 8.
It's not on the PowerPoint.
Oh, I'm sorry. This is the letter to Mr. Roundy dated March 10th, 2024. Mr. Burns,
Yes.
Are you with me?
Yes.
So we have an address there for Mr. Roundy. I'm just curious, how did you, I know he didn't collect the mail at that address. I'm just curious how it was that you determined that was his address as of March 2024.
I mean, just via a search of the realty records, we believed that was a good address for him when we researching this unit, and believed that to be a good address for him at the time.
Did your search for Mr. Roundy come up with other potential addresses or locations?
No, if so, we would have mailed to those when it came back as undeliverable.
Understood. I believe you testified that the subject well was spud, I think it was 2017. Is that correct?
Yes.
Can you help us understand the delay between the spudding of the well and the letter that was sent to Mr. Roundy about about his opportunity to participate?
Well, again, Newfield and now Ventive, we did not do many forced poolings, over the last several years, and we were trying to get caught up on all of those. And so we wanted to ensure that Mr. Roundy had an opportunity to participate, which is why we're doing this now, to try to give him the opportunity to, but also clean this up as best we can, because we did not do this back closer to when the well was spud.
To your knowledge, were there any efforts to contact Mr. Roundy between 2017 and this letter, Exhibit 8, in March of 2024?
I was not on the Uinta team at the time this well was drilled, so I can't speak to that. I'm not certain if there was. But closer to present day, I don't know that we did try to contact him up until when this letter was mailed in March.
Okay. All right. Thank you, Mr. Burns.
Board, do you have any questions for this witness, Mr. Church?
Yes, Mr. Burns, on the royalty then that is Mr. Roundy is entitled to, are you suspensing those funds? What is Oventa's practice with those kinds of royalties that are due to an unfound owner?
Yes, it'll be held in suspense until we're able to, get in touch with him and get him a lease at a future date. But for the Bar F in particular, assuming the pooling order goes through, this 17% and change will be held in suspense.
Okay, and so you will need to go back through all the years of production and allocate that amount to him and put that in suspense.
Yes, that's correct.
Do you hold that indefinitely, or at some time do you escheat those funds to the state of Utah?
Yes, eventually, if we're not able to locate him, the funds will be escheated to the state.
Okay, and I assume the well has paid out at least once at this point in time. Do you have any information on that?
Yes, I don't have the exact information. It is likely that it has paid out 100%, but I'm uncertain if it has. I don't know that it has reached 300%.
Okay, thank you.
Mr. Church, just a point of clarification. When we talk about a sheet, that means that it goes to the unclaimed property division.
Property.
Yes, okay.
Thank you very much. Yes.
Board, do you have other questions? Seeing none, please proceed.
Thank you, Madam Chair. With that, I'll commence my examination of Mr. Wall. If we could have Mr. Wall's up on the screen. Thank you. Mr. Wall, would you please state your name and business address for the record?
Yes. Name is Christopher Wall, 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
And what's your current position with Ventive?
I'm a reservoir engineering advisor with jurisdiction over this DSU as well as others in the Uinta Basin.
All right. Turning your attention to Exhibit 14, was this exhibit prepared by you or Ventive personnel with your review and input?
Yes.
Would you please explain what this shows?
Yes, it is a summary of the actual cost invoice to a Ventive and incurred in drilling and completing and operating costs for the Bar F well through May 31st, 2024.
There are some differences between this and the AFE for the well. You're going to address those in a little bit, is that correct?
That is correct, yes.
All right. Is it your expert opinion that these costs were fair, reasonable, and necessarily incurred?
Yes.
And that the well was deemed economically feasible, as that term is used in the 139-134 order to drill?
Yes.
All right. Would you please state for the record what is the estimated plug and abandonment cost for this well?
Yes, P&A costs are $75,000, which is consistent with Uinta Basin P&A costs charged to and by Ventive based on 100% working interest.
Now turning your attention to what have been marked as Exhibits 15 and 16, do you recognize these exhibits?
Yes.
And were they prepared by you or Ventive personnel with your review and input?
Yes.
All right, turning your attention to Exhibit 15, would you please explain what this shows?
Exhibit 15 is a plat of all the nearby existing horizontal development at the time the Bar F well was spud. It was the first long lateral horizontal drilled in the DSU, so we had relatively minimal control.
Now turning your attention to Exhibit 16, would you please explain this and its significance to today's hearing?
Yes. So Exhibit 16 is a summary of the risks. Starting at the top, the geologic risk, we have geosteering challenges due to the lack of well control. Also, there's variable stratigraphy, particularly the presence of high clay intervals and other structurally weak zones leading to possible hole stability issues. On the drilling and operational side, there's capital cost expectation due to the lack of well control, shallow hazards with artesianal water flows. The Uteland Butte interval has a high clay content and has potential to collapse and stick drill pipe and casing. Some recent examples is the collapse casing during completions activity of the Black Hair 7H and the Bruce 42H in 2024. Cementing challenges resulting in a loss of lateral footage on the Tomlin 46H in 2023. Also a sheared BHA or bottom hole assembly while attempting to steer in lateral, resulting in a short lateral of the Abbott 46H in 2022. Then commercial challenges, there's future oil price uncertainty and future refinery and rail car availability. And then contrary to what this exhibit says, we did encounter some problems drilling the Bar F well. During attempting to set casing, the intermediate casing, a 7-inch casing, it got stuck, requiring some fishing operations to recover the casing, then having to set a cement plug so that we could kick off and re-drill a portion of the vertical section of the well.
All right, and that accounts for the difference between the AFE amount and the actual cost that you showed on Exhibit 14? Yes, Exhibit 14. Is that right? All right, thank you. Is it your expert opinion then, for these reasons, a 300% risk assessment award is justified?
Yes.
All right, and would you confirm for the record all of the other engineering allegations of the request?
Yes.
Madam Chair, that concludes my examination. Mr. Wall.
Thank you. Division.
No questions for this witness. Thank you.
Board. No questions. Please proceed.
Thank you, Madam Chair. With that, I would move for admission of Exhibits 1 through 16 and 17 as supplemented.
Division.
No objection.
Board. No objection, so admitted.
Thank you. At this time, I would again move for the order of default against Mr. Roundy and the unknowns that was reserved at the beginning of the presentation.
No
Division.
objection.
Board. No objections.
Thank you, Madam Chair. With that, again, we believe that the statutory and regulatory requirements for the granting of the request have been satisfied, and we would ask the board to approve it as submitted. We'd also like to thank again the board for allowing the virtual participation of the witnesses and the IT people for making it go very smoothly.
Thank you. Division, any closing thoughts?
Yeah. two things. First of all, the division, based on the information, the exhibits, and the testimony, does not object to granting the request. However, the division does have some concern about the delay between the spud date and the notification to Mr. Roundy. Just as a general comment, we wonder if perhaps Mr. Roundy might have been able to participate had he known about this years before. Of course, that's an unknowable fact, but the delay exists nonetheless. So just as a comment to the board.
Thank you. Board, are we ready to make a decision, or do we need to deliberate? Are we ready? Can I get someone to make a motion?
I'll make a motion that we accept the request for agency action as presented.
And a second? Second. Thank you. All in favor?
Aye.
Any opposed? Please show that was unanimous. Thank you, Mr. McDonald.
Thank you, members of the board.
Would you please prepare the order?
Certainly.
Thank you.
I think we're changing council here, so we're going to take a quick, maybe 10-minute break while you get set up for the next presentation. We'll be back at 5 minutes to. Thank you for the request. Yeah, it's getting kind of. You were way ahead of me. Yeah, I was ready for that. I was ready. to do item number 5 on the docket. Docket number 2024-040, cause number 471-04. In the matter of the request for agency action of Heavy Sweet Oil LLC and AC Oil LLC for an order establishing the Asphalt Ridge Enhanced Recovery Unit for the in situ production of heavy oil from sands within the Rimrock and Asphalt Ridge deposits in sections 22 and 23, 4 South, 20 East, Uintah County. Ms. Dragoo. Could you turn your monitor on? Thank you.
Does that help?
Yes, thank you.
Thank you, Madam Chair. We'd like to put in appearances Jim Allen and Denise Dragoo with the law firm of Snell and Wilmer. And we're appearing today on behalf of Heavy Sweet Oil and AC Oil and requesting approval of a unitization order to establish the Asphalt Ridge Enhanced Recovery Unit.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Are you having others?
Yes, and then we just wanted to just introduce our witnesses who are going to testify today. We've got Brine McGregor, and he's the mechanical petroleum engineer and chief engineer for Valcor Energy. And there he is. Great. And Doug Hamilton, a PhD geologist for Valcor Energy. There he is. And then appearing I guess via proffer is Tara Miller, petroleum landman for Encore Land Services. And we've just discussed with the division's counsel having her affidavit, proffering her affidavit in lieu of her live testimony. But all three of those expert witnesses have provided their resumes, and they're attached as Exhibit A. And we would just submit those for the record. If there's any questions, they'd be happy to confirm, I'm sure, any of those issues. And then we also have one additional witness, and that's Stephen Bile, and he's manager of Valcor Oil and Gas LLC and designated as the operator under the unit operating agreement. Stephen, great. And should we move for ask them to be sworn at this time, or is this too early?
I think if we can swear them all in at the same time, it might save time. Can we do that?
Sure.
Can we do that? Let's do that.
Please raise your right hands.
Could everyone please stand who's being sworn in so I can see you?
Thank you. Do you?
Thank you.
Yeah. Do you solemnly swear that the testimony you shall give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God?
Great.
Thank you.
Thank you, Madam Chair. Before proceeding with the direct exam, we'd like to just give the board a little bit of background since we've been here 3 times now. So we'd like to put this in context. So maybe we can go to slide 2.
Oh, we have, Mr. Walker would like to make an announcement.
Oh.
Yeah, just a disclosure that I have met with Valcor, the operator for Heavy Sweet Oil, a couple of times in my position at the Energy and Geoscience Institute at the University of Utah. EGI may be doing some technical work for Valcor in the future. I'm not currently directly involved in doing any of that work. I don't see a need to recuse myself, but I would offer that up if anybody has an objection.
No objections by the division.
Counsel?
No objection. Thank you.
Thank you. Thank you, Mr. Walker.
We
Please
appreciate that.
proceed.
Thank you. So, as I indicated, we've, on behalf of Heavy Sweet Oil and AC Oil, we have been here 2 or 3 times now before the board. The first proceeding, as you may recall, was to approve a pilot project, and that was involved an appearance before the board in October of 2022, and then in December of 2022, the board issued an order approving the pilot project for in situ recovery of tar sands from the Rimrock and Asphalt Ridge Formation. So that order is actually in your packet attached as Exhibit G2, but we can go to the next slide. And there were some key findings in that order. The board approved the 40-acre spacing for 4 wells, and so it was clearly just a test pilot project. Although they anticipated, you anticipated the phase 2 downspacing that would be required to make this a commercial project. So the thought was that at some point, the AC oil and heavy sweet oil will come back and downspace to 2.5 acre spacing. And in addition, the other key finding was that the board defined the Rimrock and Asphalt Ridge formations as target formations consisting of tar sands. That finding was important because of the SITLA leases involved, school and institutional trust lands leases. Heavy sweet oil has the tar sands leases in that particular area, and Hoodoo Mining in production has the oil and gas leases in that area. At that time, Hoodoo did not object, although they did receive notice of the pilot project proceedings. So go on to the next slide, if you would. So our next proceeding, at the board's invitation, we did return, filed a request in April of 2023 to request unitization of the Asphalt Ridge Enhanced Recovery Unit and to approve a plan of unit operations. This request was unfortunately denied, although it was denied without prejudice. I think the concern of the board, you might go to the next slide, was that there was inadequate drilling data or production to establish the existence of a pool. So of course, the other issue was that Hoodoo, who is the oil and gas lessee, SITLA lessee in this area, protested and questioned whether or not the target formations were actually tar sands or oil. So the board determined that there needed to be some additional data or a producing well to establish that unit, and basically denied the first unitization request, but without prejudice to return. So here we are again. This is the second unitization proceeding. It's supported today by, if you want to go on to the next one there, yeah. So the new unitization request is supported by some drilling now, drilling of 2 wells, and so that drilling is going to help us establish the data necessary to show that this formation is tar sands, and then also to approve the unit order or the unitization plan and agreement for that area. Notably, the Hoodoo has not objected to this proceeding, and I won't speak for Hoodoo, but we imagine that is because the school and institutional trust lands has stepped up with a multiple mineral development agreement and plan, terms and conditions, and so they've worked hard to resolve the differences between the 2 operators, the oil and gas lessee and the tar sands lessee, and they now have a multiple mineral development area defined and terms and conditions applicable to both Hoodoo and HSO regarding how to drill and how to get along. So that's been very helpful. The school and institutional trust lands, I don't know if anybody's here representing them today, but they did file a response and some comments, and were supportive of the application today. And attached to that, their comment letter, which was filed on July 12th, is the multiple mineral development area terms and conditions. And so that's very helpful, and we've also attached that as Exhibit G3. So the data that was collected from the 2 wells that we'll be discussing today were collected according to the terms and conditions of that multiple mineral development agreement, and there was a specific analysis required by Core Lab. HSO Heavy Sweet Oil followed that requirements and the specifications for drilling and coring, and the division observed that as well. So I think that's been very helpful, and as a result, we don't see Hoodoo objecting today. So in terms of other responses, we did get a good response from the division, and they can speak to that, but they were also supportive. So in terms of jurisdiction, we might want to go to the next thing. The board has the jurisdiction to grant the relief that we're seeking today under Utah Code Annotated 46.7 and 46.8 to establish and approve a plan of unit operations for enhanced recovery within the target formations. We're asking the board to enter an order under 46.8.2 to approving the unit. And of course, there would be 2 findings that have to be determined. First, we have to show that the operation is reasonably necessary for the purposes of the Oil and Gas Conservation Act. And second, that the value of the additional recovery exceeds the cost of conducting the operations. So we will provide testimony to that effect. Second, we'll be presenting a plan of development in accordance with Utah Code 46.7.2 to show that the operations can be conducted efficiently and economically. So we'd like to go ahead and present some evidence today to show that we meet the requirements and that the board has authority to issue the order establishing the Asphalt Ridge Enhanced Recovery Unit. I did just want to touch on the notice and hearing requirements. Those have been met. The request for agency action was filed on June 10th, and notice was provided to each of the surface and mineral owners. We've got an affidavit provided by Tara Miller, and with the division's approval, we will go ahead and proffer that affidavit. It just, it's attached as Exhibit K to your package, and it identifies the surface and mineral owners, the lessees, and the interest holders in the subject lands. And based on that title analysis, we notified we notified all of the surface and mineral owners and interest holders, and then that's also confirmed in our certificate of service. So, so we think the notice and hearing requirements have been satisfied. Okay, and then I think with that we're pretty much ready to proceed with our direct examination, and maybe we'll have Stephen Bile come up first, if that's okay. Great. Let's see. Oh, there we go.
Scooch over a bit.
We need your finger.
If you'll sit in the middle.
Great.
Yeah.
Great. So to address the substantive requirements for approval of the Asphalt Ridge Enhanced Recovery Unit, we're calling on our witnesses to summarize the agreements, the exhibits, and the reports that we've submitted. I'm going to begin with the direct examination of Stephen Bile. He's going to address the form of the unit agreement, and then we'll move on to examination of Brian McGregor, who will address the new drilling data and updates to the unit plan of development. Then Mr. Allen will examine Doug Hamilton, who will address the geology of the proposed unit and the economic benefits of the proposed unit. So, yeah, going on to figure B2. Good. So, Stephen, will you state your name and business address for the record?
I'm Stephen Bile, and chairman of Heavy Sweet Oil and Valcor. And our business address, you're putting me on the spot, is on Redwood here, Redwood Drive, what's there, 2533, number 16, in Redwood Drive, in, good Lord,
Are you in Woods Cross?
in Woods Cross, yes.
Oh, good, great. And what's your current position with Valcor Oil and Gas?
I am the CEO. It is a fully owned subsidiary of Valcor LLC, to which I'm the CEO.
Okay, great. And are you familiar with the proposed Asphalt Ridge unit?
Yes, I am.
Great. And just showing you figure B2, does that figure depict the unit boundary?
Yes, it does.
Great. And then just going on to Exhibit J, showing you just the cover sheet for Exhibit J of the unit agreement. Are you familiar with the unit agreement?
Yes, I am.
Great. And does that unit agreement cover the proposed unit boundary?
Yes, it does.
Great. And does that agreement designate Valcor Oil and Gas as the operator of the unit?
Yes, it does.
Great. And in terms of the parties to the agreement for Tract 1, are you familiar with the working interest owners?
Yes, I am.
And would those include Heavy Sweet Oil, Valcor Energy, and TMC Capital?
Correct.
All right, very good. And also with respect to Tract 1, the royalty owners, do they include Sitla and Indigo Oil and Gas?
Yes, they do.
Great. And is the unit operator for both Tract 1 and 2 Valcor Oil and Gas?
Yes.
Great. And the working interest owner in Tract 2, would that be AC Oil?
Yes, it is.
And the royalty interest owner in Tract 2, is that Tar Sands Holdings 2?
Tar Sands Holding 2, yes.
Correct. Great. Very good. All right. And are you familiar with the unit plan of development attached as Exhibit B to the unit agreement?
Yes, I am.
Great. Very good. And I think what we'll do is we'll ask Brine McGregor to address that plan of operations. So I think we'll.
Fair enough. Mine was easy.
Very good.
Okay.
All right. So there may be some questions from the division for you.
Fair enough.
Right here.
Division.
Yeah, thank you, Mr. Bile. Could you explain, you mentioned Valco will operate the two units?
That is correct, yes.
Okay. Is there a separate agreement between HSO and AC that designates them operator, or is this?
It's a single agreement between all the parties, yeah.
Okay. And who, this unit agreement, have all interested parties executed this agreement? Or what is the stage of this agreement right now?
Yes, it's been executed for some time.
Okay.
By all parties.
So everybody who owns an interest in this land, they're all on board with this
That is
agreement?
correct, yes.
Okay. Yeah, no further questions.
Board, do you have any questions? Okay, please proceed.
Great. Okay, I think we'll excuse Stephen Bile and ask Brine McGregor to come forward. So Brine, would you state your name and address for the record?
Okay, my name is Brian McGregor. I'm the chief engineer at Valcor, and our address is 2511 Redwood Road, Suite 16.
Great. And are you serving in that position for both Heavy Sweet Oil and AC Oil?
Yes, I am.
Great. And can you remind the board as to your responsibilities regarding the preparation of the plan of development?
Yeah, I guess I was all of the operations side, drilling, completion, production, et cetera. I'm responsible for doing the planning and the engineering and the execution.
Great, very good. And have you testified before the board?
Yes, I have. I've testified twice, and 2 years ago I did a heavy oil 101 heavy oil for dummies presentation, I guess, or whatever you want to call it. But
exactly. And you were accepted as an expert in mechanical engineering?
That's correct.
Great. We move the board to reconfirm Mr. McGregor as an expert witness for these proceedings.
Division.
Yeah, no objections by the division.
Board, any objections? Please proceed.
Thank you. Okay, just turning your attention to the slide. This slide is marked Substitute Exhibit I, Unit Plan of Development. Are you familiar with the Plan of Development?
Yes, I am.
Great. Now, did you have prepare it?
I prepared my sections of it, and Doug and Steve prepared the other sections. It was
Great.
a team effort.
Very good. So, will you identify the sections that you prepared?
Okay. The objectives was more of a joint effort. The geological description would have been Doug, but I was responsible for item 3, which was the drilling and the operations. Parts of section 4, section 5 of the environmental protection plan, and section 6, the health safety environmental plan. Yep.
Very good. Great. Turning to the next slide.
Yeah. I might add in that, going back in that, the presentation today is going to be, Doug and I will talk about the different sections that we were responsible for. We're doing it not in order of the plan, but we just want to not jump back and forth between presenters. So I'm going to present my section, then Doug will. And we're not going to really talk about number 5 and number 6 because it hasn't changed and it's still a policy. It's not really a development plan.
Okay, great. So just turning now to the next slide.
Right.
Do you recognize this as the proposed unit boundary?
Yes, I do.
Great. And can you identify the ownership, mineral ownership within that area?
The mineral ownership in the blue would be Valcor HSO, and in the salmon or pink, that's AC Oil, or Tar Sands Holding. It goes by various names.
Great. Good. You want to go to the next exhibit? Okay, showing you figure B2. Can you describe that?
Yeah, this is, again, it's the same, pretty much the same diagram as before, but it shows the different sections of land. We have all of section 22, which is going to be part of it, the west half of section 23, and the truncated part of the east half of section 23, which is sometimes it's called D-track, but it's where the AC lands are. Highlighted in the dark red and green are the 4 wells that were in the initial approval. We did drill the 2 middle wells, and in this map it shows, this was actually shown before, it shows HSO 2-4 and HSO 15-4. 15-4 became 8-4 when it was licensed or permitted.
Very good. And is this the area that will be downspaced as a result of the unitization?
That's correct.
Great. Very good. Okay, turning to the next exhibit, I'm showing you figure B3.
Yeah, again, it's showing the outline of the 4 wells that were proposed and approved in the previous hearing. But what's been added on this well is the additional wells that would be surrounding each individual well. These wells are drilled on a hexagonal type pattern, and the interwell spacing would be about 370 feet. Now, this is only if we get approval. It's not what we do now. The wells that were drilled on the 40-acre spacing. And I'll talk about it later, but each center well, we're going to have a pad on, and we'll drill the outer 6 wells directionally from that pad. And the purpose of that is, A, to minimize cost and to minimize environmental impact.
Very good. Turning to the next slide. One more.
Okay.
Great. Can you
yeah.
identify this Exhibit B?
Sure. This is an access map to the first well that we drilled. We drilled it at 8-4. It really just shows the proximity to the town of Vernal, and it's about 5 to 6 miles west of town.
Very good.
And
can you identify the well location on this map?
yeah, this is the second well that we drilled, the HSO 204. The wells are only about 400 yards apart, So it's pretty much the same. It's the same access map. It's just a little bit further. But again, it shows the proximity to the town and et cetera.
Very good. Right, next slide. Okay,
Okay.
now turning to this slide, does this explain your current enhanced recovery operation?
Basically, this was approved. This was a slide from before, so it shows our methodology for producing the oil or the tar, the bitumen. It's called a huff and puff operation, puff and puff process, where you inject steam for about a month and produce the well back. I'm going to talk about it a little bit later, but we did add an intermediate step in there, and that's we run electric downhole heaters, and that's before we start injecting steam. And there's a few reasons for it. One of the reasons is that it's something that we can do to prove oil before we go to the to get the injection approval, or during the injection approval, we can start producing oil. But more importantly, it serves to preheat the reservoir. And if you can imagine, it's almost like asphalt. Trying to inject steam into asphalt would be next to impossible. So by preheating it, we can create a little bit of void space, so that when we do go to the steaming process, we can inject a bit more steam.
Great. So did you change the plan of development then to address the heaters?
Yes, it has. It's been changed, and we're actually doing that right now on one of our operations.
Very good. All right.
So the next slide actually does explain a little bit more.
And this slide, just for the record, is Exhibit E, page 2, correct?
Yeah, that's right. It's part of the same thing. But it just describes what we would do after we finished drilling the well. We would run the tubing in. We would inject the steam for 3 to 4 weeks, let it soak for about a month, and that just to dissipate the heat, and then produce it back. And we would produce it back long enough until it solidifies again and can no longer produce. We estimate that to be about 200 to 220 degrees, and then we would go back to the steaming process.
Very good.
Okay, and the next couple slides, I'm gonna update the drilling operations.
Great. And could you just mention when those drilling operations occurred?
They started in May of this, just a couple months ago. This first diagram is the road and pad network that I talked about earlier.
Right, and that, just for the record, you're referring to Exhibit E, page 3, is that correct?
Yes, and this was also from the previous presentation, but it does show that the red red rectangles would be the pads for the 4 wells that were approved. The yellow would be future development, and again, it would be the total field development that would be about 119 wells.
So this would be the plan if the unitization request is approved?
That's correct.
Very good.
Okay.
Now we're looking at Exhibit E, page 4. Can you describe that?
Sure. This is an update on the, I'm going to take off my glasses. I can read better without them. This is the HSO 804, which is the first well that we drilled. We spud in May 10th, and it took 7 days to drill. What we did is we drilled down to 710 feet, and there we set 8 5/8 casing. This casing was thermal cement, because this will provide the hydraulic isolation that we need between surface and the zones below, where we're going to be injecting steam. We performed a leak-off test after we drilled out, which was a requirement of part of the UIC application to do a leak-off test. We did well during the drilling operation, but we established a frac gradient of 0.75. The normal published data for frac gradients is 0.7, so we were pretty close with when we actually did it in the field. This is important because when we are injecting steam, we do not want to exceed the frac gradient. We want to more or less squeeze into the matrix and heat up the matrix rather than along the lines of a frac. It's just the more efficient distribution of the heat. We continued on. We cored the rim rock from 905 to 935 feet, which was part of the requirement. And this core was preserved. It was sleeved in aluminum. It was packed in dry ice. And then we shipped it off to Core Lab, which was an approved lab for doing the analysis of heavy oil.
Right. And when you say approved lab, was that part of the SITLA's multiple mineral development area
Exactly,
terms
yeah.
and conditions?
So we followed the conditions. And actually, one of the conditions I didn't mention here is that it was a third party that did the transportation. So HSO really didn't touch the core at all. We saw it come out of the ground. It was shipped off to the lab, and we never touched it at all.
Great. And then was that data provided to SITLA and to Hoodoo?
Yes, it was. And
Very
to Dockham as well.
Good.
So then we drilled to TD, which was 1,022, and we ran open hole logs. And part of it's for us, for edifice as well. We ran the open hole logs because we wanted to correlate to the core as well as seeing, the 30 feet of core won't cover the entire interval. So we will be able to correlate the logs to cores. And on future wells, if we just run a log, we'll be able to tell which zones are productive. And there's some stringers that'll show up. So
Good. And
okay.
did you incorporate this data into the plan of development?
Yes, I did.
Okay,
Not this particular, the specifics of the drilling, but
the results.
yeah.
Okay, great. And then did you end up getting a sample from this?
Oh yes,
Well,
yeah. We've got core samples. What we did is we sent 2/3 of the core to the core lab, and we sent 5 feet to the University of Utah, where, as Alan mentioned, we're forming an alliance with them, so we'll ship them the core. And it doesn't make sense to drive past the university on their way to the core lab. When we have the methods that we can, or methodology or equipment that we can do here.
And how about an actual sample of the oil that was produced? Did you end up getting a sample?
Oh
of
yeah,
that?
we got
Great.
it was extracted. Doug is going to talk more about the core results and the logging results in his presentation, but they did extract. I mean, we took it to it was sent to the core lab. They extracted some oil out of it and did the testing on it.
Very good. Okay.
Okay.
Great. Thank you.
I'm not finished yet.
Go ahead.
Yeah, on the completion, what we did is we ran tubing in and we swabbed the well down, and we shut it in for 24 hours. And this again was a requirement from the SITLA. We established that after 24 hours there was zero inflow from the reservoir. There was no pressure response, nothing. We ran pressure and temperature logs, and Doug will talk to those results. And then we shut down and suspended operations until we get ready for our production equipment.
Very good.
Okay, and then we can go to the next slide.
Okay, and this slide is labeled Exhibit E, page 5. Is that correct?
That's correct.
And can you speak to that?
Sure. This is an update on the second well that we drilled, the HSO 204. It was spud on the 19th and rig released 5 days later. Just a sidebar that even from one well to 2 wells, we reduced it by 2 days. So we don't expect that in every well, but it just shows the efficiency of operations and what we hope to gain by doing multiple well programs rather than one-offs. So again, on this well, we drilled down to 742 feet. We set 8 5/8, again with thermal cement. And the reason for the thermal cement is it allows the casing to expand and contract with heat, because we will be applying heat. And if you put your normal cement, it would actually crack and fail, and we'd lose the hydraulic isolation. We again performed a leak-off test. This time the gradient was slightly less, but it's in line with the published estimated frac gradient. We went deeper on this well. We cored the Asphalt Ridge, And we followed the same procedures that it was preserved, it was capped in aluminum, it was packed in dry ice and shipped to Core Lab for testing. We finished drilling to TD, we ran open hole logs, and on this well, because there was a large open hole section and the fact that we were going to run a downhole heater, we wanted to make sure that that the hole wouldn't collapse. Now that we thought it would, but just an extra insurance that we'd protect this expensive equipment. And this casing was perforated through the 2 intervals on the Asphalt Ridge and the rim rock. Now in this well, we did run a heater, so the completion is a little bit different. We did run the tubing in as well and swapped it down. We shut it in for 24 hours and established that there was 0 inflow from the reservoir. We ran the temperature and pressure logs, which Doug will talk about. But in this one, we ran a downhole heater. And the assembly we have is we have the downhole heater and then the tubing and the pump, and that runs to surface, and we install a pump jack. And the idea is that the heater would provide electric energy, heat up the oil, and it would flow and we produce it. We were seeing good signs of this. It was working good until we got to about 150 degrees, and then the heater malfunctioned. And so we're in the process of changing it out. The status is actually a little bit different. Right, as of today, we're running in with a new heater, and we'll have that probably about 1 o'clock. We'll be on bottom again, and we'll put it back on production.
Great. And once again, did you provide the data from this well to CITLA?
Yes, we did.
And to Division of Oil, Gas and Mining?
Yes.
And to Hoodoo?
Yes.
Great.
Okay, this is a timeline of what we plan to do, assuming we get approval. So we've drilled the 2 wells at 804, 204 on the 40-acre spacing, and we've installed 1 downhole heater, or we're in the process of reinstalling the downhole heater on the first well, and we'll be evaluating production. The next phase is, first off, we need to confirm equalization for the interwell spacing. And if we do that, we would drill an additional 6 wells off of the 204 location, which was the second location. And that configuration is the diagram on the left. So the center well was drilled vertically down. The outer 6 wells were going to be drilled directionally. And it'll get the required spacing. It'll finish the spacing unit. And the interwell, the surface locations, they only need to be 20 feet apart. So to amend the surface location, we only need a little bit of an extension on the lease on the north and south side.
Great. So just to be clear, this is Exhibit E, page 6. Is that correct?
That's correct.
And then when you're speaking to Phase 1, that's the current pilot project.
Yeah.
Is that correct?
Yeah, it's the pilot project, or the current 2 wells. And there's of the 4 wells that were drilled, we drilled 2 in the first phase.
Great.
And the next phase will be after we confirm the interwell spacing. We'll drill the additional 6 wells on that pad. And we've got 3 more wells that are in the hopper ready to go right now. They just need the bond to be posted. So the 1 of 4 and the AC2, both of those wells were part of the original 4-well development. And the 16 of 4, the reason we have that well is because to get to the 1 of 4, we had to survey the 16 of 4 first.
Right.
So we applied for the APD on it as well, just to try to be efficient. So we've got at least 9 wells to drill. If we want to do any more, there might be some more downspacing or additional surveying that we'll have to do.
Right.
But that'll be on the next drilling phase.
Very good. All right. And once again, all this data has been added to the plan of development.
It has, yeah. When we updated the plan of development in July this year, so to reflect running the heater as an intermediate step.
Good. All right. Well, that's my direct exam. So if the division has any questions.
Yeah, just a couple of questions. First of all, could you just go back to the last slide that you were just on? in phase 2, you talk about the 3 more wells, the 1-4, 16-4, AC2.
Right.
The division had permits, and correct me if I'm getting this wrong, a permit for an AC4.
Oh, sorry, yeah, that'd be a typo on our, but it is that.
Oh, it is
Same well.
AC4. Okay, that's the
Sorry.
same well. Okay, thank you. Just a couple questions. So we've in now rebuttal exhibit that we received, the process now contains the heater phase that you discussed.
Right.
Could you just explain briefly how long do you anticipate that heater phase to last before you moved into the huff and puff stage?
You know, it is going to depend on the results. I mean, you know, because I'll be honest, if it's producing 80 barrels a day, we might not change it. We might keep it in there for a while. But we anticipated probably 3 months at least, because we want to get the UIC approval before we go to injecting any steam. So, at least probably 3 months.
Okay.
But it's going to depend on results. We do want to, there's a reason for running it as well, to preheat that reservoir. So it's going to depend on how much production we get out of it to create that voided space to inject the steam.
Okay.
Yeah.
As to the current wells we have, the 8-4 and the 2-4, has there been any measurable production from either of those two wells?
There's nothing measurable. Like we've seen traces of oil, and it was getting up to speed, but then the motor or the heater failed on us. So,
okay.
So, we fully anticipate that within the next week we'll have production. And
okay. No further questions. Thank you.
Okay. Thank you.
Board, do you have questions? Mr. Walker?
Yeah, I just want to double check this, but when you're talking about 220 degrees, you're talking about Fahrenheit, not
Fahrenheit.
centigrade?
Yes, Fahrenheit, yeah.
Okay, good.
I've had to convert.
And the heater failed at 150?
About 150 degrees. So, it was, and Doug will show the viscosity tables, but it was getting to the point that the oil would
Almost
be
there.
movable. So it was almost there.
Okay.
And that's why we were seeing traces of it.
Yeah. And you've set your production casing in HS 2-4. Do you plan to do that also in the other well?
Yes, we do. Yeah.
Okay.
It's cheap insurance, more or less, but
Yeah. And in both cases, that'll be uncemented?
it'll be uncemmented. It's just more to protect the hole from collapsing on the
Okay.
And the next one will be slotted beforehand.
Okay. Okay. All right. I don't have any other questions.
Mr. Moon?
So I believe you, in that last question, you said you don't have measurable production yet.
No,
Is
we
that
don't.
correct?
No.
Okay. And when you do, what type of oil? You just put it in a tanker, just like regular oil, and bring it to Salt Lake, or?
Yeah, we've got heated tankers. Like the production tank there is heated, and we will use a heated tanker to come and pick it up.
Okay, and it'll be very similar to the Uinta Basin crude?
It'll be like it's when it cools down, it'll set. So we gotta make sure we keep it warm.
Right.
So the API on it is 12, so it really won't flow very well without heat. So you need the heat to keep it going.
But you're liking what you're seeing so far?
Yeah, we're very, very encouraged.
Okay.
The coring results were better than we anticipated. There's more pay zone than we anticipated. I'd allow Doug to talk to that. But even as we're producing, we could see the oil coming up. And when we did pull out, actually the last couple of days, we pulled out the old heater, and that came out on Monday, and it was covered in the tar. So it's
So
there.
if that heater hadn't have gone down, you could have brought us some
Oh, I would
to show us today.
We'd have had a tank truck going right by here, and we'll show you.
Thank you.
Yeah.
So is that crude accepted by the refineries in Salt Lake? Do they take that crude, or will they take it?
I'll let Steve.
If that's coming up later, that's fine.
Yeah.
Yeah, sorry. We have a present offtake agreement with, for asphalt. Let's go with Mountain States. And they have already looked at our oil previously and found it acceptable. We run one process towards the end. We're going to run them through a line heater to bring it up to about 500 Fahrenheit. And that will get off the diesel range organics, which will be collected separately. And then that is now an on-spec asphalt product.
Okay, so it's going to an asphalt plant, not
Correct.
to the refineries.
That is correct.
And how often would you think you would have to re-huff and puff? How does the hole cool down and you have to go through the process again?
Yeah, I mean, we were planning to huff for 3 to 4 weeks.
Right.
And then puff for 5 to 6 months.
Okay, and
that's
then
that.
repeat the process.
And repeat it. And that's, you know, we plan to do that for probably the first 3 years, and then
Okay.
we might go to the next phase after that.
Thank you.
From the core you've recently acquired and the samples, have you done thermal testing on those to see, you know, what can be produced from that per, you know, unit of mass or whatever measure you preferentially use?
All we've really done so far is extracted the oil from it, or the bitumen from it, and established the viscosity, which was part of the requirements.
And when you did that, those were some of the favorable results you were referring to? Huh?
Yeah, I mean, the fact that it's there, and I'll let Doug talk more about that. He's more of a...
Okay, thank you.
Yeah.
Mr. Galicki.
And you may have covered it, but I may have missed it. So the recovery well is, I guess my question is how do you ensure the horizontal migration as opposed to just, you know, the vertical migration of going straight down of the oil?
Sorry, I didn't. That's probably more for in the geology, but yeah, I mean, we plan to squeeze into the matrix and have it come back. So it's not just going to be isolated. We have the whole section is going to be left open, so it'll be combined production from the rim rock and the Asphalt Ridge and any stringer in between.
How much pressure do you use to force the steam?
Well, that's why we did the frac gradient test. So the established frac gradient was 0.7 psi per foot, and since this is about 700 feet, roughly 500 psi.
Okay.
Some of the wells will be deeper, and one of the reasons that we target this depth too is we want to make sure there's enough overburden on top, so that when we do inject steam, it doesn't percolate to surface. So 500 feet is our minimum that we would set casing at.
Thank you. Do we have any division? Do you have questions?
Yeah, I apologize. I neglected one aspect I did want to ask Mr. McGregor. At some point, these will become UIC wells.
Yes, they will.
What is your anticipated process of applying for the UIC permits? Like, how do you understand that there's probably going to be a time lag there, application process?
Yeah.
Are you able to address?
Well, that's really why we did the heaters now, just because of that time lag, that we wanted to. I mean, we do need to preheat anyways. It's a good technique, but it gives us something to do with the wellbore in the meantime while we're waiting for the application. So we're putting together the UIC application right now.
Okay.
And you know, the first wells, of course, we anticipate a lot of back and forth because this is brand new. But you know, with all the wells, be a lot slicker. You know, and we've even talked about when we do a 7-well pad, like we have right now, it'll be more of a group application than an individual well application.
Okay. All right, thank you.
So that was going to be my question. Do these UIC permits have to be done well by well, or can they be done on a project basis?
According to Duggan, we can do it on a
Like
on a
seven
pad.
wells, or?
Yeah.
Okay.
Yes.
Olin Wallace with the division, if it's okay, he'd like to address the board.
Thank you.
Hello, board. Orland Wallace, Division Oil Gas Mining. But so each of our wells have to be on the UIC side have to be approved individually. So that being said, down the road on the sequestration side, it's going to be, they'll still be individually, but it'll be a project. But this will be, it'll be on an individual well basis, because we have to, there's several things we have to verify within that well bore, the casing, the cement, make sure that things are isolated properly on each individual well.
Okay, thank you.
You bet.
Any other questions from the board? Mr. Moon.
So you mentioned cement, but we're not cementing here.
We're cementing the 8.5 or 8 5/8 casing string. So that's why we put the thermal cement, because that's going to provide the hydraulic isolation.
Okay, so there's partial
Yeah.
cementing.
And that's part of our discussions, how we're going to do it, if with either we use a thermal packer on the 5.5 and 8 5/8, or because we do need to keep that isolation. We don't want any steam coming to surface.
Okay.
So that's between Orland and myself to come up with the correct.
Mr. Church.
So the well that's used for the heating unit, will that be used for any other purpose?
Well, right now it's going to be heated. Eventually, it'll go to a huff and puff.
It will convert to
It'll convert to a huff and puff, and we'll probably follow this methodology on most of our wells. That the heaters can be rerun on different wells. So the process would be drill a well, heat it for a while, produce a little bit of oil, but heat up the reservoir, apply for the UIC, and then when we have the UIC, we would put it on steam.
And what's the source of energy for the heating units?
It's electricity. So right now, well, I can address that now if you want, but right now we're just using a portable generator, and we've actually started to talk to Rocky Mountain Power, because we'd like to electrify the whole field, just purely for economics. It's about a 2-year process to get that approval and installation in place, but it's driven by economics.
Thank you.
Any further questions? Mr. Grew, please.
Great, thank you then. We'll dismiss this witness and call Dr. Hamilton. And I'll defer to Mr. Allen, who's going to do this direct exam.
Good morning. It's still morning.
Yes, I was
apparently.
wondering.
Yeah. Would you state your name and address for the record, please?
Douglas Hamilton. I live in Arizona, 1332 North Clagato Road, Golden Valley.
And what is your position with respect to this project?
I'm the chief geologist for Valcor.
Okay. Is your education experience summarized in the resume we have in Exhibit A?
Yes, it is.
Okay. Madam Chairman, at this time I'd request that Mr. Hamilton again be recognized as an expert in geology.
Division?
No objections.
Board? So accepted.
Thank you. Referring back just briefly to the unit plan of operations that was prepared and that appears in Exhibit I, would you identify the portions of that of the table of contents that you were involved in and that you're going to speak to today?
Surely. Yes, so I was involved in the geological description, the well spacing analysis, the full field development, and I was looking at the cost assumptions and economic analysis.
Okay. Are those the topics that have got the little stars by them on the side?
Yes.
Okay, thanks. From there, board members, we're going to start moving through the various pages of Exhibit C. Dr. Hamilton will just ask you to explain what's being depicted here on Exhibit C1.
Right. So these exhibits were part of the original pilot approval, and so we were required to present the field and details thereof. So these have all been presented to you before, but I'll go over them briefly now. So this is the geological outcrop map that you would observe if you were walking across the territory. We see in the D tract on the right-hand side, you've got the Mesaverde outcrop. There's a lot of quaternary alluvium covering most of the region, and then the topographic areas to most of 22 and southwest part of 23 is the Duchesne River Formation. That they form the hillsides there that the local guys like to drive their bikes and quads over. So next one.
And just to be clear then, the yellow shaded area, is that where
that's the Duchesne River Formation, correct.
Is that where the deposit is underground, or
Yes.
where it exists?
Yes. In fact, the deposit goes from the Mesaverde outcrop and in the orientation to the northwest. So the deposit's beneath the cover, all the way from a line drawn from the Mesaverde outcrop to the northwest corner of the map, and then everything to the south and southwest.
C2.
So this is the net pay map of the Rimrock Sandstone. This will give you an idea of the distribution of the sands now. We see there's a number of wells have been drilled. The Tom Brown drilled several wells in 1974. Those are labelled, we're twinning those, the HS1, HS2, the ACD. Well, the ACD2 in 2023 section, we drilled that 2 years ago. And the orientation of the sands is from basically west to east, and there's a north-south trend up to the Mesaverde outcrop. So we're up to 250 foot thick of net pay in the Rimrock Sandstone, and most of those thicknesses have been confirmed by past drilling. And I'll talk about our 2 new wells where we've confirmed the thicknesses of the sand in the central part of the area. Now this is a map of the Asphalt Ridge Sandstone. Again, you can see we've got quite thick sands. We go from 60 foot in the west, that was in the Tom Brown number 1 well, and it thickens to the east in Tom Brown number 1, which is right on close to the boundary of section 23. The sand was 123 feet thick there. The ACD2 well, or the AC2 well, we did not drill too deep enough to see the Asphalt Ridge. We terminated the hole at the bottom of the Rimrock Sandstone, so we don't have a data point. But the projection of the regional mapping indicates that the sand should be about 200 foot thick over to the east.
Moving to Exhibit C4.
So this speaks to the drilling depths. Everyone's interested in knowing just how deep are all our wells going to be. So this is the depth to the top of the Rimrock Sandstone. So in the HS2 well, the depth was 750 feet. The deeper wells down to the south, so the beds are dipping fairly steeply down to the south and southwest. And down in the Tom Brown 2 well, the top of the rimrock was at 1,766 feet. So this is the depth drilling down the hole. We're not concerning ourselves with topography here. Just how deep would the well be?
Moving to C5.
So this is the depth to the top of the Asphalt Ridge, and this will indicate the deepest drilling that we're anticipating in the unit. The Tom Brown 2 well was 2,364 feet to the top of the Asphalt Ridge. You can see that the strike of the beds go from the west to the east, and they dip steeply to the south. So in the Tom Brown number 7 well, the Asphalt Ridge was intersected at 394 feet. So we're just going to get deeper and deeper as we go to the south.
What's depicted on Exhibit C6?
So this is a cross-section, a dip, what we call a dip section, going from the Tom Brown 7 well down to the Tom Brown 2. You can see in the yellow we have the Rimrock and Asphalt Ridge sandstones. These are the heavily oil-saturated sandstones. And the brown colour in the cross-section is the interbedded shale rocks. So we have the Mancus Shale lies beneath the Asphalt Ridge. That's a bottom seal, if you like. What they call the Mancus Tongue separates the Rimrock and the Asphalt Ridge. That's in the middle of those two reservoirs. And then the Duchesne River and Uinta formations they're either shaly, or when they're sand and conglomerate, they're quite tight. So we're not reviewing those as being potential target zones. So we're focusing in on the Rimrock and the Asphalt Ridge sandstones.
You slipped this in. We almost missed it. You referred to a bottom seal. Can you talk a little bit about the characteristics of the formations above and below our target zones?
Yeah, so the Mancos Shale and the Mancus Tongue, these are marine shale rocks, so they're quite tight. They're siltstone and claystones interbedded, very thick, thousands of feet thick in the Mancus Shale. The Mancus Tongue itself gets up to about 120 foot thick, separating the two main reservoir zones. And just to repeat, the Duchesne River and Uinta formations, these are interbedded, what they call vari-coloured conglomerate sandstones and shales, where they have very high density. Is one thing that shows up on the logs, is extremely high density. So these have been when they're sandstone and conglomerate, they've been well cemented, so they're tight.
Thank you. Exhibit C7.
Yeah, so this was the original cross-section of the reservoir zones that were required for the first approval. So we're looking here at the Tom Brown 5 well on the left-hand side. The Tom Brown 6 is the second well. At the time, we had the Heavy Sweet number 8 well, which is shown by that blue rectangle. And then on the right-hand side, we have the ACD well, which you see is red there. That's actually, we intersected that. That's the Rimrock sandstone, just under 100 foot thick. I could not get a well log down that hole. We had the loggers turned up several days after the well had been completed, and they couldn't get the tools down. So I'm just representing that as a stick diagram, if you like. But the Rimrock sandstone extends from the extreme west of the field all the way to the AC well, which is toward the eastern part of the D tract. Similarly, the Asphalt Ridge sandstone, very extensive. The Heavy Sweet 8 well is a projection, so that's the blue stick. But the Asphalt Ridge sandstone is intersected in the Tom Brown number 1 well, which you can see just above my cross section. So we know the Asphalt Ridge is extensive from drilling at least to the western part of 23, but regionally, when I did the regional analysis down to the Asphalt Ridge, we see the sandstone member there is very extensive as well. So we've basically got our two reservoir units are extending right across the application area.
Moving to what we're calling C7A, a new exhibit. What's different about this?
Yeah, so what we've done here now is we've added in the results of the first two wells that we've drilled. So you see the two wells on the left-hand side, that's the Tom Brown 5 and the Tom Brown 6. And then the third well from the left-hand side, that is our new well, 2 of 4. And that we drilled down into the Mancus Shale, and you can see the very thick Rimrock sandstone at the top. This is very similar to the Tom Brown number 6 well, and it should be because it was designed as a twin. And we also get the Asphalt Ridge sandstone. Very, very good reservoir quality here, heavily bitumen saturated, as we expected it to be. And then the next well to the right, that's the 8 of 4. We drill that through the rimrock sandstone and terminated the well into the Mancus tongue. Once again, we had excellent reservoir quality, very thick sandstones. We cored the section from 905 to 930 feet. That's what went to core labs in Canada for the analysis of the crude viscosity and API gravity. So here we have our 2 new infill wells demonstrating the geologic model that we had put together for the first approval.
And based on this information, and I'm going to ask you for an opinion. So if a well were drilled into the rim rock at any location within the proposed unit area, in your opinion, would it be producing from the same source as any other well within the unit area also drilled into the rim rock?
Yes, it would.
And is that also true with respect to the Asphalt Ridge formation?
That's also correct.
Thank you. We're at C8 now.
So this is again, this was required in the previous approval to have a regional section of the geological analysis. So this was a section that goes from the southwest to the northeast, from the Uinta Basin proper up to the Ashley Valley. This was published by Schammel in a 2009 publication by the state of Utah. And the red box there is that small little box which I've expanded just to show the stratigraphy of our area of interest. And you can see the rimrock sandstone at the top, the Mancus tongue in the middle, and the Asphalt Ridge member. These are all members of the Mesaverde group, or Mesaverde formation as variably called. And the bitumen impregnated sandstones are shown in that black cross hatching. So that's our area of interest on a regional scale.
Exhibit C9.
Yeah, once again, we were required in the previous approval to show lithologic or electric logs. In this instance, we had gamma ray and bulk density logs from the Tom Brown drilling. So that's the 6 and the 5 well showing there, and they were presented in the previous cross sections as well.
C10.
And once again, having a reference well was a requirement of the previous approval, so I selected the Tom Brown 5 well, and its location is shown there, circled in the yellow. Once again, just showing very thick rimrock sandstone and Asphalt Ridge, very familiar stratigraphy, both here and regionally.
Moving to the D group of exhibits. Would you comment on figure D1?
Yeah, so this was in the Schammel report. The 2009 Department of Natural Resources had commissioned this study to understand the potential strategies for in situ recovery of Utah's heavy oil and bitumen resources. And Mr. Schammel selected a well in the D track. It was at the LETC site where many experiments were done. And what we're illustrating here is the bitumen saturation in these sandstones. So this is the rimrock sandstone, and all that cross-hatching you see is indicative of bitumen saturation.
We're moving now to a new exhibit that we're designating Exhibit D 2.1.
Right, so this is the results now of the recent drilling project that we've done, the 2 wells. And what I'm showing you here is the pressure and temperature. So we had to demonstrate to Sittler and to Doggham what reservoir pressures we're talking about and what reservoir temperatures to determine the nature of the bitumen. So what we did here, this is on the left-hand side, the blue line is the pressure, and the red is the temperature. And on the bottom we have time. So this is an active log that's moving. So at time 0, we're at the bottom of the hole. So we've run the tools in, let them equilibrate with the reservoir, and then started the move at time 0, pulling the tools out of the hole to surface. And so you can see that at time 0, the pressure is 180 psi, and then we see the pressure gradient changing now as the tool is being pulled from the hole all the way down to time 9 minutes. that's going through the fluid level. So there's water sitting in the hole. So we've gone from the bottom at 180 psi. We've come through the fluid level up to the end of the fluid level, and and that's at 9 minutes. And then the pressure log goes flat, straight line. That's atmospheric conditions. So we've come out of the fluid level into open hole, and we're dealing now with just the atmospheric to the end of the test. In terms of the temperature log, that's your red line, and the scale is in Fahrenheit on the right-hand side of the graph. So at the bottom hole, we're dealing with 53.6 degrees Fahrenheit at time zero, and as the tool is pulled from the well, the temperature is basically stable all the way through to time 22 minutes, and then you see a little fluctuation there. That's as it's being affected by the atmospheric temperature that day. It was a cool day, the day we ran that, so that's a bit below the 53. So the reservoir temperature equilibrated for the rimrock sandstone is 53.6 degrees, and that's in the 8 of 4 well.
So we're now at Exhibit D 2.2.
So as Brine mentioned, we drilled the core. This is the rimrock sandstone. We cored it. It was the transport company were there present on site as we pulled the core out. They put it in. He put it in, or was in aluminum sleeves. He immediately applied dry ice to it to preserve the core as it existed, and then drove that through the night up to Core Labs in Calgary. Then at Core Labs, they extracted the crude from the core, and then they ran 3-point test, which is standard practice for viscosity measurements, and then extrapolated to cooler temperatures and higher temperatures. And I'll show the graph going forward. But the bottom line here is the viscosity at the reservoir temperature is projected to be over 1 million centipoise, and we were required to prove that our least substance was bitumen, and the definition of bitumen is heavy crude of any gravity that's greater than 10,000 centipoise is defined as bitumen. And so these were the tests we were required to run to satisfy Sittler, the state, and also Hoodoo, who were arguing that there was mobile oil in these reservoirs, and the Core Lab data clearly showed that that was not true, that it is bitumen. And if we go to the next one, Jim, this will illustrate it better. Go ahead.
We're at Exhibit D 2.3. We made a correction and resubmitted this exhibit. Go ahead.
Yeah, so this is for the rimrock sandstone, and it was in the 8-4 well, and we're showing the viscosity versus temperature in the graph. So viscosity on the left, temperature on the right. The curve that you'll see, the 3 red dots, these are the actual data points measured by Core Lab. It's impossible to measure viscosity when you get up above several 100,000 centipoise. The equipment is inappropriate for doing that testing, so the commercial labs don't actually measure viscosities that are 1 million centipoise. You have to go into mercury injection and some very old equipment that occurs in just a couple of the universities in the United States to measure such heavy viscous crudes. So the 3 that they measured, these are all measured using the standard ASTM D341, which is an internationally recognized measure of viscosity. And the three red dots are the actual data points, and they're measuring at 100 up to just shy of 150 degrees in Fahrenheit. And then Core Lab then extrapolated other points at 53.6 degrees, which is the reservoir temperature in Fahrenheit. It's the Core Lab's projection is a 1 million centipoise, and then down at 402 degrees we get to 3 centipoise. And so all those numbers are all calculated by Core Lab by the standard methodology of the ASTM D341 internationally recognized measure. And then we put a curve to the data points, and we got a correlation coefficient of 0.9978, which is about as good as you can ever get for an extrapolation. And so what the analysis showed is that we are bitumen at reservoir temperature by definition. We wouldn't see crude less than 10,000 centipoise till about 115, 117 degrees. So this demonstrates that the hydrocarbonaceous material in our tenements is in fact bitumen, and that's the least substance. So we've demonstrated that amply here with this, and then we've got the second well we drilled for the Asphalt Ridge.
All right, let's just spend another minute on this if we could. There's some language quoted in a white text box there at the bottom. To explain where that's coming from and what the significance of that is.
Yes.
Again?
So that's the definition of our least substance. What Valcor has leased from Sittler, and that is any consolidated or unconsolidated rock, other than coal, oil shale, or gilsonite, that contains a hydrocarbonaceous material with a gas-free viscosity measured at reservoir temperature that's greater than 10,000 centipoise. So that's the definition of our least substance, and this is a core lab analysis, independent verification.
All right. And at what temperature does the material from the rimrock sandstone transition below 10,000?
Yeah, so we've got on that really good curve, we've got 115 degrees Fahrenheit is the temperature at which this crude would be less than 10,000 centipoise.
Did you ever encounter a temperature of 115 degrees in your drilling?
No, we didn't. The two wells we drilled in the rimrock sandstone, it was the reservoir temperature is 53.6 Fahrenheit, and in the Asphalt Ridge, which is a bit deeper, in the other well, it was 59 degrees Fahrenheit. So we got nowhere near the kind of temperatures you'd need in the subsurface to make this crude go below 10,000 centipoise.
Did we detect did you detect a temperature gradient with depth?
Yes, I did. I'll talk about that now, and demonstrate it in the Asphalt Ridge data. But we got 53.6 Fahrenheit at 900 odd feet in the rimrock sandstone. The Asphalt Ridge was at 1193 feet, and the temperature had risen to 59 degrees Fahrenheit. That represents a 1 degree increase per 51 feet. So when we then we can use that as a very accurate temperature gradient with hard data. Temperature gradients can be difficult to evaluate when you don't have straight measurements from well bores. But since we had two, we came up with that 1 degree per 51 foot. And if you calculate from 1193, which is where the Asphalt Ridge was intersected, at 59 degrees, and then multiply that by 50 feet per degree, you get to 115 degrees Fahrenheit at around about 4,200 foot. So you'd have to be in excess of 4,000 feet deep before you would see this crude below 10,000 centipoise. It's based on our thermal gradient. And if you probably don't recall, but if you can visualize the Asphalt Ridge map, which is the lower of the two units, we don't get anywhere near that depth in this acreage. Our deepest drilling is going to be around 2,500 feet.
We're now at Exhibit D 2.4.
So this is the temperature pressure analysis in the 2-4 well, which was drilled down to the Asphalt Ridge, as I mentioned. Now we're going to do something tricky here. We're going in reverse. In the previous graph you saw, we were at the bottom hole coming out of the well. In this one, they ran the temperature pressure log from the top down to the bottom. So again, pressure is in the blue line, and the temperature is in the red. So at time zero in the pressure, we're at the surface at time zero. And we stay at atmospheric pressure through to time 20 minutes. And then you see the pressure rise sharply up to about 240 psi. That's as the tool's going through the fluid. That's the fluid zone. The bottom of the hole is underneath the Asphalt Ridge sandstone reservoir label there, and that finished up at about 240 psi. And then they pulled the tool back out of the well, and you see the pressure dropping rapidly up to time 31 minutes. At that point, we're back out of the fluid level and into the atmospheric, and then you see atmospheric pressure through to the end of the test. In the temperature log, which is in the red, we enter the well at time 0, and it was a warm day in Vernal that time. It was over 80 degrees, and so as the tool goes down the well, the temperature reduces, and then reduces sharply when we hit the fluid zone, the fluid level, and then to the bottom of the reservoir at time 22, and then time 22 through 30, we're equilibrating with the reservoir temperature, and the answer there is 59 degrees Fahrenheit. The temperature again is on the right-hand side of that graph. And then we start to pull out the hole, and as say from time 35 minutes, we're seeing the temperature increasing. That's because we're getting back to the surface of the well, and the cylinder's seeing the temperature at surface. So this is diagnostic of a temperature of 59 degrees, and that's shown from time 22 minutes to 30 minutes in the graph.
The next exhibit, D2.5.
So we did the same procedure for the Asphalt Ridge sandstone. We cored it, and typically the core comes out at 2 o'clock in the morning. And we had the courier from Core Lab collect the core, wrapped in aluminum sleeve with dry ice, and then he drove it straight to Calgary and delivered it to Core Lab. And then they ran the same tests again. They extracted bitumen from the core and measured it at 3 separate temperatures, and then did the standard extrapolations to the reservoir temperature and down to a low temperature, so we'd know where we'd be when we applied heat to the reservoir. So let's go to the next slide, which shows it graphically.
D2.6.
So again, the Asphalt Ridge sandstone reservoir at well 2-4. The reservoir temperature there is 59 degrees, and at 59 degrees it was 660,000 centipoise. So that's all designated bitumen. The 3 data points that Core Lab were able to measure were at 100 degrees and going up to about 148 degrees, if I can see that in the temperatures there. So the extrapolated viscosity per the ASTM D341 shows that this crude is 660,000 centipoise at 59 degrees Fahrenheit, and you would have to go down to 117 degrees, or go up to 117 degrees till you got crude below 10,000 centipoise. So that's just 2 feet difference than the rimrock sandstone. So that's pretty accurate measurements. So we plotted the points. We got a correlation coefficient of 0.999 here, so that's about as good as you get. And we have the same box of text there that talks about our least substance is a hydrocarbonaceous material with a gas-free viscosity measured at reservoir temperature greater than 10,000 centipoise. So we're at 660,000 centipoise at reservoir conditions, so we're well above any definitions of bitumen there.
Shifting gears now to the last topic we have, which is the economics of this project. Let's start with figure F1. If you discuss that.
Right. So this was the early modelling that we did prior to any drilling and any analysis of live data. We was based on a literature search. We were assuming that the reservoir temperature would be in the range of 50 to 80 degrees Fahrenheit. So we based our temperature on the modelling. As it turns out, we're talking about 53.6 to 59, so we were well within the range. The reservoir pressure we estimated at 440 pounds. That's hydrostatic. Now, of course, hydrostatic is between 0.43 and 0.46 psi per foot of depth. So that number will vary depending on where you are, how deep you go. So 440 sits in the middle of the range of hydrostatic and that would be at that depth. We assumed that the lowest known bitumen, based on regional analysis, was 4,000 feet subsea, so that's depth down the hole. And the bitumen resource is immobile at reservoir conditions. That was our preliminary assumption. So with that, we ran some simulation with Amanda Buston in Canada, presented this information at the last hearing. And so here's the results of the thermal modelling. What I'm showing you here is the heat distribution modelled obviously in a computer. I think it was Sparks. So the first box on the top left-hand side is a 10-acre spacing, or a 745 feet of area from the central location out to the receiving wells. So these are all 7-spot patterns as we're proposing to develop this resource. So the centre hole at 10 acres, the temperature distribution after 30 years would look like this. So you've got a core of yellow and orange colour, so we're talking about at that 425 degrees Fahrenheit. And then you can see that the temperature of blue is down near reservoir temperature around 70 degrees. So after 30 years on a 10-acre spacing, you would never see any heat in the producing wells. So that would be worthless to us. At 5 acres, we see the temperature distribution after 30 years, where we start to see heat arriving at the well bores, the producing wells. At 2.5 acre spacing, which is what we think is the start of commercial potential, we see a good heat distribution after 30 years, reaching all of the producing wells. At 1 acre spacing, after 30 years, the heat has gone beyond the producing wells and is affecting the reservoir beyond that development pattern. And then at 1/2 acre spacing, you can see the heat expanding even further. So that leads us to a optimal spacing of somewhere between 0.5 and 2.5 acres. So then on the right-hand side, we calculated or modelled what the production would look like in those different spacing arrangements. And so the graph is from 0 to 360 months. The 10-acre spacing is the black line. If you can see that, it basically remains flat and takes 30 years before you get to 50 barrels of oil per day. Now, the jagged nature of the first 30 months is the huff and puff stage. The standard model here, it's been well developed in Canada and in California, is you do a huff and puff for roughly 3 years and then convert to a steam flood. That's the norm. And of course, there are many elaborations on that. The quality of the steam that you inject. You can inject carbon dioxide, flue gas, which is 87% nitrogen and 13% carbon dioxide. So there's many different ways that you can run these actual injection profiles. So if we look at the production as a response, so you've got your huff and puff for the first 3 years and then conversion to steam flood. If we looked at the 10 acre, we'd never be commercial. If we looked at the 5 acre spacing, which is the purple line, you can see that at 240 months, you would get 250 barrels of oil per day. These are also uneconomic. You've got all the front-end capex, and then you don't actually start to see much oil production for 240 months. So let's work back to what are feasible development patterns. So 2.5 acre spacing, that's the green line. So the green curve shows about 90 months, you're up at 300 barrels of oil per day. During the huff and puff stage, you get up to 250 barrels a day, but that's of course spread between periods of injecting and then periods of producing back. The 1 acre spacing looks very good, 350 barrels of oil a day in about 40 months. And then of course the 1/2 acre spacing gives you a peak of 350 even sooner. So we'll go to the next slide. So we've done some pattern recovery factors. You want to say that?
Yeah, this is figure F3.
So this was preliminary modelling, and I want to emphasise that because this is just giving us an indication. Right? It's indicative of what recovery factor we might expect at the different acre spacings. And the best acre spacing is obviously the half acre, where we were modelling about 45% recovery factor. And as you go out to 10 acres, you get a 2% recovery factor, simply because you're not getting heat to the producers. And then we also have the modelling of the oil in place, original oil in place, in thousands of barrels that the pattern can access, right? So we're looking at how far out, how much oil is contained in that cylinder of your well spacing. So it shows that from 0.5 acre to 2.5 acres, you get pretty reasonable recovery factors. We actually get a lot better than this. This is preliminary modelling. The 2.5 acres can access 174,000 barrels of oil from which we can draw, whereas a half acre reaches 31,000 barrels of oil. Now, the half acre spacing, as it turns out, it's uneconomic, simply because the capital expenditures required to drill it, that would exceed the accessible recoverable oil. So we eliminated the half acre, and our ideal is lying between 1 and 2.5, and we've designed 2.5 as our starting position, and that's the program that's in the report. 17 well spots, 7 spots, which is a total of 119 wells, is what we're modelling at a 2.5 acre spacing. Now, very important to us is this unitization agreement, because the current rules allow us to drill on 40 acre spacing. On a 40 acre spacing, here's one well would produce, from our modelling, would produce 15,000 barrels of oil. The 40 acres original oil in place is actually 7.6 million barrels. That's how much oil is in that 40 acre area. But because the heat only gets out, well, it doesn't get out very much at all, so we can only recover about 0.2% of the oil in place. And the net present value at a 10% discount rate calculates out at a minus $0.57 million. So that's uneconomic by any measure. So we have to downspace to make this a commercial enterprise.
And by downspace, you mean
unitize?
Yeah.
Yes, unitize is required to come below 40 acre spacing. So it's absolutely essential to the commerciality of this project.
Figure F7.
So this is a comparison of the different development spacing. So first of all, the one well case is what you just saw. One well over 30 years would produce 15,000 barrels of oil from a potential 7.6 million available. That's a recovery factor of 0.2% and a very negative MPV. The full development, we would produce 53.15 million barrels of crude oil. That's from an oil in place calculation of 129 million barrels. That represents a recovery factor of 41.2%, which is very good for steam thermal injection projects. We calculated out an NPV with a discount of 10 valued at $637 million. So this is commercially very lucrative, and the actual full development case is probably hard to see from here, but we're basically going through the crude that could be produced, the net oil, then you've got the gross revenues, you've got the taxes, the OPEX. OPEX we calculated about $26 a barrel is what it's going to cost us to produce this. And then of course the royalties and taxes. The initial investment is based on 119 wells drilled. We're estimating $750,000 per well to produce and complete. That number is very, very pessimistic. We went for the highest possible number we thought. And you might recall that Brine discussed that we saved 2 days rig time on the second well from the first well. So that's substantial. Going from basically 5 to 3 days, you're getting close to half your rig costs. So the $750,000 that we put into the investments in the second to last column, that represents a very large upfront input, which reduces the MPV at the 10% discount rate. If we reduce those costs, we can get much more attractive economics, though the economics are very attractive anyway. But we went to independent reviewers, and we'll go to the next slide.
Before we do that,
Yeah.
let's walk through this a little more carefully, because there's a finding here that the board has to make. Does this figure F7 indicate the costs of developing a well without unitization and the costs of full development under a unit plan of operations?
Yes, yes it does.
And does it also present the expected revenues in
Yes.
both of those scenarios?
Yes, it does.
And what is your conclusion regarding whether the projected revenues do or do not exceed the costs?
Right, so a one well case, as summarised at the base there, that's if we had 40 acre spacing, which is the current statute. That would have a very negative MPV10 and would have an extremely low recovery factor and would be really a waste of the resource. The state would be very concerned about recovery factors and preserving the resource. Whereas the full development is quite the opposite. We see recovery factors of 41.2%, which is really taking care of the resource and developing it in the most profound and sensible way. And then the MPV 10 of $637 million makes it a highly attractive, viable project.
Okay. Thank you. And this is based on analysis that Heavy Sweet Oil did itself.
This is our own analysis, but I would point out that our costs of drilling were established by us based on the first two wells, drilling and completion. So you've got to complete the well, of course. So those costs that went into that are very high, and we think we can do a lot better than that, which will make the MPV 10 a lot more attractive.
Thank you. Moving now to Exhibit F8. What are we talking about here?
So this is an independent contingent resource certification by Netherlands, Sewell & Associates. These are world-renowned certifiers. They're actually conservative certifiers. You can get bigger, better numbers from a lot of the other certifiers, but Netherlands, Sewell are internationally recognised, and they are quite conservative in their analysis. And so we thought this is a great group to do an independent indicator of whether or not we have a good project here. And the answers they came up with, some very, very similar to our own indication. They found that there was 129 million barrels of oil in place. That's their best estimate. They ran a Monte Carlo simulation for this, so they come up with a low, best, and high estimates. Then they calculated what we should get in terms of recovery factor. So if you look at the category 2C development pending, that's a net contingent oil resource of 58 million barrels. And then they did their economics analysis of the net contingent cash flow, and the total was worth $1.94 billion. And then when discounted at a 10% discount rate, they came up with an analysis of $1.02 billion of the net contingent cash flow. So highly attractive commercial production project, independently verified by Netherlands Sewell. So, we feel like we've satisfied the commercial requirement to justify a unit agreement to downspace to 2.5 acre. Or just be able to downspace to the optimal acreage that we will learn. We're going for 2.5 initially. We may change that to a little tighter as we go.
Thank you. That concludes our examination of this witness.
Division, do you have questions? I think after this questions and answers, we probably need to break.
Sure. Yeah, we don't have very many questions. Just while we're on this Netherlands and Sewell exhibit, though, I do have a question. I noticed it's dated November 16, 2023. I don't know what data they used to develop their numbers, but the new data you have on the size of the thickness of the pool, the reserve now. Would that alter these numbers, do you feel, or could you speak to that?
Yes, I can speak to that. Well, first of all, these analyses are good for 1 year. Okay, so Netherlands Sewell will not stand on this number on November 17th, 2024, but this is current. The data that they do their analysis on is partly what we provide them, plus historical data. So they had all the Tom Brown drilling and the mapping that had been done previous, and all of the state of Utah publications and historical data. They set up their own grids, so and they do it slightly different to me. I set up my grid deterministically. They tend to opt more for the stochastical type analyses. So they come up with their own thickness maps on a grid. They input all the viscosity, the porosity, permeability analyses that were published, and there's quite extensive. There's 380 cores in this small area. So they take all the independent data, plus they look at our maps as well. And they come up with their own conclusion about what the reservoir looks like and what the reservoir parameters, and then they run a standard engineering simulation, plus given their background internationally of thermal stimulation projects as well. So they draw from international studies. So,
yeah. Okay, thank you. Yeah, again, the board's permission, Peter Banke from the division would also like to ask a question.
I'll make it quick. Peter Banke with the division. I'm just curious. I noticed that it looks like the 8-4 well was only drilled into the Mancos tongue, not all the way through the Asphalt Ridge.
Right.
I'm just wondering why that was the case, and if there's plans, because I know the development plan is what it is, and you'd obviously like to get the Asphalt Ridge portion. Just wondering what the plan is with that well.
Yeah. The reason for the drilling change was made on the run. We had, we're in the early phases of our investor capital, and we have some preconditions to the investors for our next pot. It's one of the reasons we're putting heaters in here, because once we've produced 100 barrels of oil from the well, we qualify for the next tranche of money from one of our investor groups. So that's very important to us being able to move forward. We did a quick calculation on the drilling of the 8-4 well, and at that time we got approval for our 2 well. If anyone knows, or I know you guys know, that there was an underground water tank situation problem with our 2-4 well. That was our first priority. Our highest priority well was to drill that one. We were unable to because of the discovery of water tanks in the subsurface when we were preparing the pad, and the state had to investigate, and it took them, actually did it really fast, and we're very, very, very pleased that they helped us out. But they came back with the answer when we were drilling the 8-4 well and said, you are now allowed to drill the number 2 well, right? You gave us approvals while we were drilling this 8-4 well, and we said, and that's the well we wanted to drill in the first. So our highest priority well would be the first pad. So we made the decision to terminate the first hole below the Rimrock sandstone, because we had just enough money in our bank account to drill fully our main priority well. So in 10 years' time, when somebody looks at what these guys did, they're going to go, why didn't they drill the 8-4 well to the Asphalt Ridge? Well, that's the reason. It had to do with monies, approvals, and it was prudent to move to and maybe one day we'll deepen the 8 well. But we'll address that when the appropriate time. So it's a bit of a story, but that's why that happened.
That's perfect. Thank you. Answered.
Does the division have any further questions?
Further questions by the division.
Board, do you have questions for this? Mr. Borden.
I just wanted to touch a little bit on on an environmental issue. I know you weren't planning to discuss it today, but I just want a sort of an overview of what you've thought about this. The rim rock sandstone looks like there's an angular unconformity.
Mm-hmm.
You've got some rocks over the top. There's a water table somewhere in there. Is there any water resource used near that contact, as far as an aquifer or any production well?
No, I actually did an analysis of the aquifers some time back, and all of the ground flow is to the north into the Ashley Valley. We're actually on a divide to the south where there is no active aquifer. And the drilling that we did in the AC well, we saw no water, and the 2-4 and the 8-4, no water zones. So the answer is no. There's no active aquifer in 22 or 23.
Okay, so you showed a plan view map of basically a thermal modeling to see where the temperature gradients extend out to. I assume those are also extending vertically.
Yeah, up to
and
yes.
they're not touching anything that might be.
No. Yeah. So the convection is it's in a vertical plan looking down, and of course the convection goes like that till it hits the seal, and the seal is the unconformity.
Okay, so the unconformity is a low hydraulic conductivity.
Correct.
Unconformity.
Yeah.
Yep. Okay. Thank you.
Any other, Mr. Walker?
Yeah, thank you, Dr. Hamilton. It's a very good presentation. When you did your temperature and pressure surveys, there was fluid in the well. What was the nature of that fluid, and where did it come from?
Yeah, that's for Brine too.
Okay.
Yeah, that was just when we.
Come forward.
Yeah, the fluid in the hole was after drilling. So
Please identify yourself.
Oh, sorry, Brian McGregor.
Thank you.
Yeah, the fluid in the hole was left after the drilling process, and we moved on the tubing and we swabbed the well down as low as we could possibly go, and that's why on the one well it was 550 feet and the other one was 960.
Okay, and how long had that fluid been able to sit there and stabilize?
Oh, it was at least a week.
Okay.
And that's part of the reason why we did the temperature log with cased hole, because after drilling, the temperature was about 75 degrees from the fluid. So we wanted to negate the cooling effect, or the warming effect in this case, of the drilling fluid.
Yeah, so you wanted to equilibrate with the reservoir temperature.
Exactly. Yeah. So that's why it was at least a week that we waited.
Okay, that's plenty. Okay, and I saw a lot of places where you had oil saturations in the 60s and 70%. What was the source of that?
That data was published by Steve Schammel in the
Dr.
2009 state report.
Okay, so Steve got something from...
Yeah, a lot of that stuff came from Tom Brown drilling. Okay. Tom Brown sent, I think it was 380 core samples which would have been Core Lab in Denver at the time. And so that all that data was all collated in the Tom Brown report, and Steve summarised that. Plus, I think he looked at all the outcrop saturations as well.
Okay. So in your economic assessment, you used a number in there someplace, the 60 to 70%?
Yes. Yeah. In matter of fact, Steve Schammel did an average table, so he went through all the data and then put an average saturation for each of the units. And so I used those numbers in.
So you integrated that whole
yes
into your analysis. Great. Okay, I don't have any other questions.
Okay. Do we have any? Mr. Galecki.
Real quick, can you go back to figure 4 in the, I don't know if it's, I know it's in the report, it's figure 4. Let's see. Keep going back. The one that shows the patterns of the 2.5 acre, each acre plot. Okay, that one.
Oh, the thermal modeling, yeah.
So the spacing, as you said, like 2.5 acres and 370 feet. Is the 370 feet, that's the distance from the main hole?
That's, main hole to any of the 6 spots around that distance is the
And
370 feet.
You know, that's kind of representative. It doesn't take that dip into effect in that, you know, the dipping of the beds. It won't be that same shape because it'll be flowing differently. Right?
That's true.
Okay.
Mr. Moon?
So what would you say is the biggest risk for this project just not working? What would?
Well, we've now seen the bitumen in lining the rods. That would have, you know, as the heater went up to 150 degrees, and we actually got some, you know, splotches on surface. So we've demonstrated that this bitumen will be mobile once it's heated up. The pump, the heater broke or something broke in the system, and I don't know the details, but that then cooled down and froze again. So we've demonstrated that we can get the crude to temperature. It'll move. It's mobile once it's hot. I don't see mechanically a problem, a risk there. So it'll come back to the usual risks of oil price. You know, if oil price crashed to $30 a barrel before we got some of our capex back, the project would not look so good. But we do have, as Stephen Bile indicated, we've got multiple marketplaces. We've got offtake agreement for asphalt. Of course, the asphalt will come down a bit, but it's not like West Texas Intermediate that goes from, $80 to $30 overnight. Our OPEX is at $26 a barrel. So if we return our capex, if oil prices stay high enough to return the capex, we can be commercial at $30 a barrel. So, but I think that's the economics. Is the prevailing oil price is probably the biggest risk. We've got ultra low sulfur crude here, and that's highly prized, in particularly in the marine engine world. All the environmental protection agencies internationally all decided to crack down on the bunker Cs, the fuels that the marine industry was using, and now they're forcing them to use low sulfur fuel sources. And Utah is 4 or 5 billion barrels of the good low sulfur stuff, so it's got long-term legs to support the international marine industry.
And in the short term, you have the investor, you have the money to just keep going along. And
yes, yeah, Steve could probably address that more accurately if you want to know. But we produce 100 barrels of crude, which we hope to do within the next month. That gets us our next tranche of money, and I think we're up to, if I'm right, 14 million. That'll fund a couple of the pilot projects for sure. So we're ready to go.
Sounds good. Thank you.
Thank you.
Board, do you have any other questions? Mr. Walker?
Yeah, Dr. Hamilton, with this really high oil saturation and the thickness of do you have any concerns about subsidence? And is there anybody live out there either? It's been a long time since I've been there. And I don't.
No, there's nothing there.
ATV routes and stuff. So.
The rock. If you've seen the cores, well, you've seen some of the cores. You see they're thoroughly lithified, right? The matrix is solid.
So it was a sandstone before it got saturated, then.
That's right. The migration into the pore spaces would have been post lithification. So diagenetically, it's solid. You've got quartz and calcite. So the rock is really competent. Mm-hmm. The only risk I would say is we don't, and this is the reason we're putting in a slotted liner, is it's possible that we could loosen up the matrix.
Oh, that's near wellbore.
Yeah, near wellbore. So that wouldn't be. So I'm not anticipating a subsidence problem. That usually occurs when you've got unconsolidated rock, and then it is a big problem. So
yeah.
So we've got hundreds and hundreds of feet of core that show that this is all lithified. So
okay, thank you.
That looks like, any more questions from anyone here?
getting hungry, so we'll stop.
I know. Division, do you have any follow-up or anything? Back to you, Mr. Gru. Do you have any other witnesses?
We have no more witnesses. We were just going to do a short conclusion and then and then request the board to admit our exhibits. So.
Okay, let's go ahead and finish up with summation.
Okay, great. Jim, why don't you?
You look hungry, so I'll move. I'll move through this.
It is a very hungry board.
As quickly as possible. You know, as you look at the history of tar sand in Utah, development of tar sand resources by in situ methods has been something that's been sought for more than 40 years. As we sit here today, as you've learned, we're within weeks of seeing that happen, and I think that's very exciting. But returning to the task in front of us today, in front of you, I should say, the statute provides that the board shall provide for unitization if two things. Unit operations are reasonably necessary for the purposes of the statute. The purposes of the statute include promoting development, providing for greater ultimate recovery, and providing for voluntary agreements among operators and owners. I think the evidence presented today indicates that moving forward with this project on a unit basis supports those objectives. In fact, that this project is reasonably necessary to support those objectives for this particular resource. And second, that the value of the estimated additional recovery from unit operations will exceed the estimated additional cost of those operations. We had 3 lines of evidence there. We had comparison of the full unit development cost versus the conventional single well development. We had studies regarding the optimum drilling pattern and size, the heat maps that you saw. And third, we had the independent report from NSA with the contingent resource and cash flow projections. So I think, or I would submit to the board that there's ample evidence presented into the record today to support the 2 conclusions that need to be drawn to approve unit operations. I just want to touch on issues that have come up in as we've appeared before this board before. Ownership of the resource, of course, was very, very sharply contested. That is resolved by the multiple mineral development agreement prepared by SITLA and brokered by SITLA among the various parties claiming an interest in the resource. And it established the 10,000 centipoise cutoff that Dr. Hamilton spoke today. The second issue had to do with does the evidence show that there is a pool or a common source of supply? And I think Dr. Hamilton again provided testimony that drilling a well in one part of the unit or another part of the unit or tapping the same source based upon his analysis of the continuity of these 2 deposits across the 2 sections we propose to unitize. The additional drilling did not show up any particular offsets due to faulting or anything like that, as you saw from the profiles. Actual core samples were obtained and sampled and showed remarkable consistency from one sample to another. So I think that, again, the issue of do we have a common source of supply within these 2 sections, yes, we do. There's a common source of supply with respect to the rim rock formation that, as you heard from both Brine and Doug, looks pretty good. And then there is continuity and consistency across the Asphalt Ridge formation the Asphalt Ridge member as well. And so I would suggest that the existence of pools are part of a pool, to use the language from the statute, is amply supported by the evidence here. And so with that, members of the board, we would request that you grant the relief asked for in the request for agency action.
Thank you for the presentation. Mr. Crew?
And then we just wanted to move to admit our exhibits.
Okay.
Just trying to move through these quickly. Exhibit A were the petitioner's witness resumes. Exhibit B included the plats showing the area of interest, including figure B1, B2, B3, B4. Exhibit C included maps and plats presenting the geologic and engineering data that Doug Hamilton presented. That was figure C1, C2, C3, C4, C5, C6, C7. We had two of those, and we'd like to use the substitute comparison of developments. Never mind. We're fine with C7.
I have a 7 and a 7A.
Yeah, right. Okay. 7A, 8, C8, C9, and C10. And then Exhibit D include the maps, plats, and drawings prepared by Doug Hamilton showing the oil sands within the target formations. And let's see, we have a figure D1, also have a figure D2, and then we have figures D2.2, D2.3, D2.4, D2.5. They were submitted as rebuttal exhibits, and D2.6. Then we go to Exhibit E, which included the drawings prepared by Brian McGregor describing the proposed operations. And that included Exhibit E1, Exhibit E2, Exhibit E3, Exhibit E4, Exhibit E5, and Exhibit E6. Then we have Exhibit F, which were drawings, tables, and graphs that showed the characteristics of the reservoir, including F1, F2, F3, F4. Skipping then to F7, which was the substitute comparison. That was submitted as a rebuttal exhibit. F5 and 6 were withdrawn. And then F8, that was the report prepared by Netherlands, Sewell and Associates. Then going to Exhibit G, these are the orders which are really just helpful. Exhibit G1 is the board order dated June 20th, 2024. Exhibit G2 is the board order dated December 8th, 2022. And Exhibit 3 is our SITLA's multiple mineral development area terms and conditions. And then Exhibit H is a certificate of service confirming that all the operators and owners and surface owners, the subject lands were provided notice. We're going to Exhibit I, which is the substitute plan of development and operations reflecting the comments provided by the division. Exhibit J, the substitute unit agreement, which reflects the division's comments. And then Exhibit K, the landman's affidavit, which is proffered in lieu of Tara Miller's testimony. And we would move to admit those exhibits.
Division?
Yeah, we have no objections to those exhibits.
Any board comments? Indeed. These were the two rebuttals, 2.3 and 2.6. Okay, so admitted.
Great. Thank you. Thank you, Chairman. Thank you, Board.
And I think the board is going to need to discuss this, so we're going to take a lunch break and some deliberation.
We
I'm
will
sorry.
not take long.
I'm sorry. Division. I keep forgetting you guys. You're so quiet.
That's all right. We're just back here. Yeah, we're hungry too. Yeah, just before you deliberate, we'd just like to point out that as was in the division's response, permitting the production of oil through heavy sands is new to the division. It's a process that we haven't been doing in the past, and as this has come before the board multiple times, the same development. We've had many chances to look at the process and what the petitioners are asking. In this case, there is no longer, in our mind, a dispute as to who has the right to produce this heavy oil. So we're okay with that. Sitla, who is the majority mineral interest owner in this case, is in support. They've filed their support here. So we recognize that support. The petition exhibits and testimony they gave today, as far as the division is concerned, also prove that there is a pool in this unit that's being requested. So again, we feel satisfied that has happened. All parties have also, as the testimony showed today, all parties that have an interest have agreed to the unit agreement. So they're all in agreement on how this will be developed, this area. So with that in mind, the division has no opposition to the request here today. The one caveat is just, as has happened in past hearings, anything that happens here will require division technical review as to the UIC well process. So just keep that in mind, that will also be a hurdle that they will face in each step. But the division has been working with the petitioner. We've had communication, so we feel like there's a good relationship there. So any hurdles that come along, we're confident that we can work through those. Thank you.
Thank you. Any final thoughts? Okay.
Great.
We are going to deliberate. We'll probably come back in, 45 minutes? Is that enough time? So at 1:45, we'll reconvene and discuss our deliberations.
Great.
Thank
you, Madam Chairman.
We are off the record.
No kidding. Yes, that was good. Thank you.
Check, 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 check. That one, I'll do C. Mic check. Bravo. Oh. EFGH is Bravo's ABCD. Check, check. Check, check.
Welcome back. We are live in 5, 4, 3, 2, 1.
We are back on the record and reconvening this docket. Do we have any further questions before we proceed? Division, do you have any questions?
No further questions, no.
Board?
Yes,
Mr. Walker?
I'd like to ask one question of the division. Given that, we've been through fits and starts on oil sands in the past, and this is new ground for you guys, how do you feel about are you feel confident that you've got the bonding and the protection for the state of Utah, given that we're going to have somewhere between, there's potential we could have somewhere between 2 and 119 wells that you might have to take care of. Hopefully not, but could have to.
Sure.
What do you guys feel?
Yeah, I know the current 2 wells that they have in there that are bonded. As to the entire project, could either of you speak to bonding on that level?
Yes, just Orland with the Division Oil, Gas, and Mining. As far as the bonding on these wells, I think with the amount that we've got on these and the nature of the wells and how shallow they are, I think it would be sufficient to plug them. However, we're in the process of changing our bonding rules because we've come to see that a lot of the wells and out there, to be able to reclaim the whole pad plus the wells, is costed us quite a bit more than what we charge for bonding currently on them. So on this project, yes, there's not a large pad disturbance, and the wells are less than 1,500 feet, most of them. So I feel that the bonding on these, now if this is just going off current inflation rate and things, the cost of what it is right now, could take care of it. Could take care of each well. But that being said, if things go up, hopefully the new bonding rule, when it's established, will help in the future. But as of right now, I think we have enough to cover the wells currently as they are.
Okay, thank you.
Just a quick question. Is there any difference in the bonding? So the initial well, you have the location and the well. Is there a difference when it's a second, third, fourth, fifth well? Or is it the same amount per well bore?
So it's all the depth of the well. So it's all the same amount. It goes to a certain amount of the depth of the well. The bonding does. The good thing about these is, I would have to clarify with Sitla, but Sitla carries also a surface bond on them to cover anything on surface. So at least on all of our deep wells they do. So that right there would give us sufficient bonding to take care of what we need to take care of.
But let me just, for my own understanding, you're going to bond that center well, let's say. Are each of the 6 surrounding well bores also bonded, or is everything bonded with that one well?
No, every well that has
leg?
an EPI has to have a bond on it. Yep.
So every leg is bonded?
Yep, every well, whether it's the one that's going to take the oil up or whether it's the one that's going to inject steam or whatever, all of them will have a bond on them.
How many acres of surface disturbance are there roughly? Does anybody, the ones you've drilled? Please identify yourself.
Brian McGregor.
Thank you.
The standard lease right now for one well is 150 by 150 feet. And then when we expand it, there'll be, for 7 wells, it'll be about 150 by 300.
Okay.
So it reduces, by putting them on a pad, it reduces the surface impact significantly.
Thank you. Do we have any other questions? Are we ready for a motion? Mr. Walker?
Sure. I'd like to make a motion to approve the request for agency action as requested.
Do I have a second? Second. It's been moved and seconded. All those in favor?
Aye.
All those opposed? Hearing none, the measure carries unanimously.
Great. Thank you so much, Chairman and Board.
Thank you. I'm going to request that Board prepare the order for this one, just because we're on new territory here. And so Paula will be submitting things for your review here in the near future. And with that, do we have any other business? I think we are looking for an adjournment. We are adjourned. She's still hungry. We're off the record.